past instigates some things, but this is just wrong. "14 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, ETGs and PBTs on demand of the probation department. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to order that you attend the anger management program with 8-week follow-up. You're to maintain employment and provide proof. You're not to have any contact with Jennifer Fawkes. You're not to possess firearms. You are not to possess dangerous weapons. You are to pay fines in the amount of $100, costs in the amount of $225, $75 victims' rights fee, $50 justice assessment. So your fines and costs here amount to $450. Screening fee is $60 for 510, and you have probation fees of $280, bringing your total to $790. You were never in custody on this case, correct? You never were taken to the station?
Yes, it was
Were you in custody for one night?
4 nights.
4 nights? Okay. 9 days jail credit 4. I'll let you serve the other 5 on the court work program. So you're going to do 5 days on the court work program, and that is a charge of $35 a day for a total of $175. And you have plus your $790, your total is $965. If you violate, your probation could be revoked. You could be incarcerated for up to 365 days. You have 21 days to appeal. You have 14 days to apply to the court-appointed lawyer for purposes of appeal. And you may be eligible for early discharge. There was no statute that was taken under, correct?
No, you're right.
You may be eligible for early discharge. So if you complete everything and there's no violations within the preceding 90 days, you can apply for discharge. By statute, you would be entitled to it after 7 months. Do you understand?
Yes.
All right. Do you have any questions?
No, Your Honor.
All right. Thank you very much. Can she pay all this?
No, Your Honor. Can she have time to pay?
How much does she have today?
$100, Your Honor.
Okay. And you are making not much. How much can you afford to pay weekly or bi-weekly?
Probably $100.
Weekly or bi-weekly?
Bi-weekly.
Okay. 100 now, 100 bi-weekly. I'll give you some leeway time, so we won't start that until June the 29th. How's that?
Thank you, Your Honor.
And if you ever need more time, no problem. Call the court. We'll go on Zoom, or you can come in here on or before any due date at 8:30 in the morning. I'll be glad to give you an extension. Okay?
Judge, can I just double check her total?
Double check the total. You're probably right. I'm probably wrong. So let me.
No, you cut out at one thing, so I just want to double check.
Okay, I got 100 fines, 225 costs for 325. I have 75 victims' rights, $50 justice assessment for 450. Screening fee is 60 for 510. Probation fees are 280 for 790. And I've got 175 in court work program fees, 5 days on the court work program. So the total I came up with was 965.
Got it. Okay, we're good.
Okay. All right. You'll meet with probation. Have a good day, ma'am. Do everything you're supposed to do here, please. Okay. Good luck. Felsky. Thanks, Ms. Belcher.
Thank you, Your Honor.
And Michael Andrew Felsky, 26W703474.
Good morning again, Your Honor. Leanna Belcher on behalf of Mr. Felsky. Mr. Felsky should be present on Zoom. Mr.
Felsky, start your video, please. Your name, sir?
Michael Felsky.
Okay, so we're going to proceed to the exam.
That is correct.
All right, so sir, you're going to have to be here in person next week, okay?
Yes, sir.
That will be June the 16th. June the 16th at 10:15 a.m., okay?
Yes, sir.
Any questions?
No.
Anything else, Ms. Belcher?
Good. Thank you.
Thank you very much. Do you have any others?
That's
Have a great day. Thank you. Do I have out there yet? Are they here on Ferguson?
Yes, they're all on Zoom.
Okay. I'm going to take this one with Ms. Acock real quick. Alexandra Boyer.
Good morning, Your Honor. Leslie Aycock on behalf of Ms. Boyer.
It's 267-691-4225. Okay, your appearance?
Good morning, Your Honor. Leslie Aycock on behalf of defendant Alexandra Boyer with permission to stand in for her today on the civil infraction.
All right, so she's going to plead to limited access. You're authorized to enter in that plea. Limited access, 11 to 15 over, with the understanding that 25 over will be dismissed, correct?
That is correct, Your Honor.
All right, like you said, you're authorized to enter this plea on her behalf?
That is correct.
To that charge on her behalf, responsible or not responsible?
Responsible, Your Honor.
Hope you've talked to her about her speeding. She's going to have a real bad way to go. She keeps driving like that. 195, and I'll give her till the 16th to pay, okay?
Could she have a little more time? She indicates to me her next payday is June 26th. So that's a Friday.
June
Would it be possible?
29th, June
Thank you.
29th, okay?
Thank you very much, Your
But
Honor.
honestly, her record driving like that, 102 is not good. All right, thanks a lot. Have a good day.
Thank you.
All right, people against Kobe Rashar Ferguson, 25B. Hang on one second. Give me 1 second here. I don't need to call the one case, so I'm just going to call Kobe Rashar Ferguson, 25B 728899. Okay, everybody's appearances, please.
Good morning, Your Honor. Madison Oro on behalf of the people, PA 8398.
Where is Mr. Martell?
Judge, he was out there. I'm not sure what happened, unless this is him in the not guilty law.
Ready, Judge. Thank you.
Oh, there we go.
Your appearance?
Good morning, Your Honor. Good morning to your fine staff. May it please this most honorable court, Edward Martell, P85051, on behalf of Mr. Ferguson, who joins us via Zoom. Young man, please unmute yourself, show your camera, state your full name for the record.
You have to state your name, sir.
Mr. Ferguson, please unmute and state your name, sir.
Mr. Ferguson, I need you to state your name, sir.
I do apologize, Judge. Bottom left, sir. There's a little microphone. Hit it, please. State your name. Judge, on behalf of Mr. Ferguson, I would ask the Honorable Court to acknowledge his presence, and I would waive any further presence at this time. Considering
Mr. Ferguson, will you do me a favor and unmute in the bottom left-hand corner of your screen? And then tell me your name.
I do apologize to the court.
Mr. Ferguson, I need you to unmute. Can you hear what I am telling you, sir? Why didn't I just have him come in person? You know, I just... Mr. Ferguson, stop, unmute your video, please.
And Judge, I do understand the frustration of the court. While Mr. Ferguson was found as competent judge, there certainly are some developmental delays. So he may be technologically impaired. I do acknowledge that that is my client on the record if the court wants to move forward.
I'd really like to have him hear and know that he's hearing this. I really would.
Judge, may we pass this matter for 5 minutes? I can call his mother.
I'll be happy to have that, you do that. I'll pass it for a couple of minutes. Thank you.
My apologies, Judge. Thank you.
That's all right. I need those.
Oh, you're at all of them? Is there a seat?
All right. I'm getting close to requiring the defendant to appear on that in person. If he can't figure it out, Lisa, you can tell Mr. Ferguson that he has to appear in person and make sure.
Let's log back in. So Mr. Ferguson, can you hear us? Can you unmute and start your video?
Hello, yes, Kobe Ferguson.
Can you start your video? Okay, stay right there now. Now
Hello,
let's get the
yes, I'm
lawyers.
so sorry. My phone is acting up.
You're fine. You're fine. Don't worry about it. I just want you to be able to hear this. So let's get his lawyer in here. Ms. Trombley has a civil infraction. Do we have that one down there anywhere?
Yes, Kobe Ferguson.
Just wait 1 second, sir. Just wait 1 second. Just stay right there, please. Do you have a case that you've done with Ms. Trombley, priority waste?
We just write those up. The priority waste ones are again.
This is going to take thank you. It's going to take a few minutes, so I'll get you out of here if I can.
Thank you, Your Honor. I appreciate it.
Where is Ms. Oro and Mr. Martell?
Judge, I'm here, just waiting for Mr. Martell.
Okay, good enough. Where's Mr. Martell at now? Lisa, do we have him out there anywhere?
He's not in the waiting room. Maybe he logged off to call his client.
Oh, boy. How you doing? Do we have his number, Lisa? Can we try calling him? Maybe
call him.
he's. Thank you. If you want to log back on, I still don't have that file, Ms. Trombley. If you want to leave and go back to some other court, that's fine. You can log back on, but I can't, I'm not going to go back there and force him to write it up. And I'm not going to work.
I have a 9:15 and 36, so I feel like I'll be stuck there. So I'll hang out for a few more minutes.
I don't know why they didn't bring it in, but I know they're busy, so I'm not going to criticize.
Yeah, no problem.
Judge, Mr. Martell did not answer. I will call the prosecutor and have him bring in priority waste.
Thank you, Lisa.
Tell them to bring in whatever they have. I got no files here. I'm not going to start those sentencings yet, John. I'm not going to start those sentencings until after I render this decision and get some of these other people
I'll
out.
handle someone else.
Sorry.
No, that's fine, Judge.
Morning, Judge.
She's on her way in with priority waste.
Thanks, Lisa.
You're welcome.
I can write that down. All right, People Against Priority Waste LLC, 260-27215. Ms. Trombley, your appearance.
Yes, good morning, Your Honor. Elizabeth Tremblay appearing on behalf of Priority Waste.
In this case, this is a charge of spill load / leaking. Does your client stand mute, waive formal reading?
Yes, Your Honor.
Not guilty, please enter. Prosecutor to dismiss. As the defendant is in compliance with the law, the case is dismissed. Priority Waste LLC, 26SO27-216 A, B, and C. Your appearance again, please.
Yes, Your Honor. Elizabeth Tremblay appearing on behalf of Priority Waste.
This defendant stand mute, waive formal reading on the misdemeanor of spill load.
Yes, Your Honor.
And now, as I understand it, the prosecutor is going to dismiss that case after your client pleads to overweight with agreed upon fines and costs of $1,177, and with the understanding that the C file spill load will be dismissed and the defective equipment will be dismissed, correct?
That's correct, Your Honor.
All right. On behalf of your client, first of all, are you authorized to enter into that plea on behalf of your client?
Yes, Your Honor.
That charge of overweight violation, responsible or not responsible?
Responsible.
I'll accept the plea, assess fines and costs of $1,177, paid by July the 9th. And I'm going to go ahead and dismiss the defective equipment and C file, the misdemeanor of spill load. Okay.
Thank you, Your Honor. Thank you, Your
You're all
Honor.
set.
Have a good day.
Thank you.
Thanks.
What else do you have down there? Where is Mr.
Sure.
Martell? There
Mr.
you are.
Martell's back online.
All right, now let's go. Ms. Oro, come on here, please. All right, there we go. People against Kobe Ferguson. This is file number 25B728 899. Your appearance, everybody?
Good morning again, Your Honor. Madison Oro on behalf of the people, PA 8398.
Mr. Martell?
Thank you, Judge. Good morning, Your Honor. Good morning to your fine staff. May it please this most honorable court, Edward Martell, P85051, on behalf of Kobe Ferguson. Young man, state your name for the record.
Judge file. I think it's understood.
Right here.
Mr. Ferguson, if you haven't already, state your name.
Mr. Ferguson, state your name. State your name, please.
Ferguson.
You got to be more clear with it, sir. State your name again. I need your full name.
Kobe Ferguson.
Thank you. All right. So there's 3 counts of CSC. There's 3 counts of CSC. There's 1 count of assault with intent to commit great bodily harm, less than murder or by strangulation. Prosecutor acknowledged that she didn't prove it as to one of the counts. There were only 2 incidents here. Mr. Martell, I'm going to give you your choice. There was no proof of age of the defendant. I'm either going to let the prosecutor reopen their proofs, or if you wish to stipulate that he was born on June 1 of 23, then that's up to you. Whatever you want. If I allow them to reopen their proofs, it's going to be with respect to the defendant's age only.
Judge, we would stipulate to my client's age.
So you stipulate that
to his age only.
September of 25, he was the age of, I'm sorry, as of September of 25, he was 22 years old, correct?
That is correct, Judge.
All right. So for purposes of exam, court will accept that stipulation. I said I wanted to think about this. I did. The testimony provided this, that the victim, whose name I'm not going to mention, was born in May of 2011 and was 15 at the time of these incidents. She attended a local high school in the 9th grade. She became acquainted with Mr. Ferguson. They had 2 different incidents, I should say. He told her that he was 16. She was 14 at the time when they first met. He said he went to Trenton High School, which that turned out to be untrue. But nonetheless, they had 2 sexual episodes in September of 25. They started doing something in the first episode, and honestly, she described her private parts as being her chest and the area from her waist down. She talked about, the prosecutor asked her some questions about what she was referring to. She said, she described peeing as being his genitalia, and she referred to hers as that. She said at one time they were both naked. He was on top of her. There was movement, she said, for 4 to 3 minutes. She said the entire episode lasted. The second incident was kind of the same. They were later at a different residence at one of her friends' houses. They were doing the same thing in the bathroom, and somebody knocked on the door saying the food was ready, and they stopped. And she said that was for 2 or 3 minutes that incident took place. There was no testimony or evidence with regard to ejaculation. There was no evidence that there was actual penetration in the court's view. The prosecutor argues that there was, because they were on top of one another, and that there was movement in the genitalia area for 3 to 4 minutes on an occasion, 2 to 3 minutes on another occasion. The prosecutor cited the case of Bristol, and I just find that so different. People versus Bristol at 115 Mish Ave 236. And in that case, the victim was a 4-year-old girl. In response to questioning by the attending doctor, said the defendant's penis actually went inside, and she experienced a great deal of pain at that time in the area of the vagina. And there was an abrasion of the labia minora, which would make that, and I think the case stands for the fact that if there's penetration or some kind of penetration into the area of the labia minora, that is sufficient evidence of penetration. But there was testimony to show that penetration of the vagina to a physician would require an entry into. The point is, in this court's view, there is simply not enough evidence for penetration. There is enough evidence for sexual contact. The defendant was more than 5 years older than her at the time. And I'm simply going to indicate that I'm not binding over on CSC3 because, again, there's just not sufficient evidence of penetration. There is sufficient evidence of sexual contact, but I'm not going to bind over on that count. I'm going to bind over on 755-520E. That person, there's sexual contact in the 4th degree if the person engages in sexual contact with another person, and that person is at least 13 and less than 16, and the actor is 5 or more years older than the victim. So in this case, the age qualifies. I'm not binding over either on the assault with intent to do great bodily harm less than strangulation. Yes, the victim said he had his hand on her neck for about a minute. Yes, she said it got to be uncomfortable. There was not simply enough testimony developed to establish that there was restricted blood flow as applicable in that section that would qualify for that. So I'm simply binding over on 2 counts of CSC in the 4th degree. I'm dismissing all 3 counts of CSC. Wait a minute, let me repeat that. I'm binding over on 2 counts of CSC4. I'm dismissing all 3 counts of CSC3. I'm also dismissing the count of assault with intent to do great bodily harm less than murder or by strangulation. Defendant is bound over for further proceedings to the Wayne County Circuit Court. He's not in custody, so we're going to have the AOI on. That would be what, Lisa? The 23rd, right?
Let me double check. Yes, the 23rd.
June 23rd. And let's see.
And Judge, just to clarify, if the parties were not allowed to state their stance, because I wasn't able to argue anything today. I thought that was the purpose of today's proceeding. It sounds like, Judge, you just stated everything that you had already stated last week. But
so
I haven't.
You guys argue last.
Listen,
this was not the purpose of today. I let you guys argue last. Listen to me. Counsel, you're getting a little too aggressive with me. I don't want to hear this anymore from you or any other lawyer. Sounds like you already made up your mind. I heard that from you 2 or 3 times last time. I told you how I felt about this. The only purpose for me, I said I wanted to go back and review my notes and review the tape. And I told you guys, you could submit other cases without having to brief them. I specifically said, I'll be glad to entertain any other cases that you have. And all you have to do is say, Judge, please read so-and-so versus Smith and cite the case. Nobody did that. I didn't receive anything. I heard your argument last time. I told you then I didn't believe there was penetration. I still believe it now. You don't like it? Appeal. But I don't like you arguing with me. And I don't like you telling me last week 2 or 3 times you're a young lawyer, but I don't like you telling me, sounds like you already made up your mind. I made up my mind based on the lack of testimony and the lack of evidence.
Okay, Judge, thank you.
Did I not, if I didn't let somebody argue, shame on me, but I don't think that was the purpose was to come back and argue. We'd already covered this. You moved the bind over, he argued, you argued.
You did, Judge, and I think I misunderstood because I think you stated to submit the case law, and I think that's where my misunderstanding was. I had case law to argue today, so that's my misunderstanding, and for that I
specifically said to you guys, don't come to court with the case law. Send the case law to me beforehand, and the record will reflect that, and I will read it. I wasn't going to burden you guys with briefing anything because I can read.
That's okay, Judge. I apologize. I got that.
I don't mind lawyers disagreeing with me, okay? It's going to happen every single day. I do mind lawyers getting smart with me. And I thought you got smart with me last week, and I don't appreciate what you just said now. What do we have as the bond?
Judge, my intention was to not get...
Dates. Lisa, what do we have with the bond on this case? It looks like Judge Hessen cited a different...
Let me check. I'm bringing it up right now.
812, it looks like she said 50,000, 10%. But these are 2 different incidence dates. And she just referenced the other one. So unless somebody can tell me something, counsel.
Yeah, there's no bond on that 899.
Well, I got to set one. I'm going to set one now. So do you have any objection at this point? He's bound over on 25B 725812. Do you have any objection to a personal bond, Ms. Oro? If you do, feel free to argue it.
Judge, I wouldn't have any objection at this time, though I will say at the time that the other case was in front of Judge Hessen, she did make the bond for both cases the same. I don't know if that's not showing up on the 2 cases, but she had reflected.
No, I agree with you. She referenced the other case, but he posted the 50,000, 10%. So I'm going to leave that on the other one, Lisa. I want to make sure the record is clear. There's to be 50,000, 10% on 25B 725812. And I'm going to set on this case 50,000 personal bond. No contact with the victim or prosecution witnesses, not to enter 24591 San Marino apartment 103. No alcohol, marijuana, or illegal drugs, no firearms or dangerous weapons, not to be within 5 miles of the victim, her residence or place of employment, no unsought supervised contact with any child less than 18 years of age. Do you understand that, Mr. Ferguson?
Yes.
And so your date will be June the 23rd. Thank you all. Have a good day.
Thank you. Have a good day.
Thank you. Have a great one.
James Trucking. James.
Ready, Your Honor.
Let me call this whole case. I'm sorry, James Berg Trucking Company, 26S118457. Appearances.
Michael Levitt, I represent James Berg Trucking Company, Your Honor.
How you doing, Mr. Levitt? Sorry to keep you waiting. There's an overweight here. What is this charge? Exceeded posted bridge.
Yes, Your Honor. It's an overweight bridge violation.
Right, and there's agreed upon fines and costs of $3,500. True.
That is correct. And
you're authorized to enter that plea on behalf of the company?
I am.
To that charge, how do you plead, responsible or not responsible?
Responsible.
Please accepted, 3,500 paid by July the 9th. People against, is this yours too, counsel?
I have Payola
Yeah.
Express.
Pahoa Express Inc., 26SO25075A and B and C. All right, your appearance again?
Michael Levitt, I represent Payola Express Incorporated.
All right. So what are we doing on this one? There's going to be a plea of overweight with agreed upon fines and costs of $1,700, true?
No, Your Honor, I thought the reduction would be $1,177.
They wrote down 1,700.
That would be an error.
Are you on this?
Yes.
I'm sorry, your name?
Court Roulette with Wayne County Sheriff's Office.
Okay, you were the issuing officer?
Yes, Your Honor.
Would you do me a favor? Do you think this is an error? Do you agree with what he said?
It is an error. I was in there. I wrote the wrong fine amount, and when I first came in here, I corrected. So what he said.
I'm going to get him out of here. I'm going to ask you to take this in real quick to the prosecutor and have her change that. Will you do that for me? And then there's going to be a plea to overweight with agreed upon fines and costs of $1,177. And that's what you're telling me, correct, Deputy?
Yes.
All right, so I'll ask you to take that into her right now.
Okay.
And then there's going to be a dismissal. Let me just see here. That's on the A file, 75A. And then there's going to be a plea to overweight, which is the C file, correct, Mr. Levitt?
That is correct, Your Honor.
All right. And they're going to dismiss the C file, right?
They're going to dismiss.
I'm sorry, the B file, the B file.
Correct.
And that's defective equipment. And you're authorized hearing these pleas on behalf of the company, true?
I am, Your Honor.
All right. So to the charge of overweight on file A, responsible or not responsible?
Responsible.
To the charge of overweight on file C, responsible or not responsible?
Responsible.
All right. And I'll accept those pleas. I'll dismiss the B file on motion of the prosecutor. That's the defective equipment. All right. Thank you. So we are all set. I'm going to assess fines and costs. He's made that correction on here, 1177 on the A file overweight. I'll make it 300 on the over width, and I'll give you until July the 9th to pay on both of those. Okay.
I really appreciate the courtesies this morning, Your Honor. Thank you.
Have a great day. Always a pleasure.
Yes, likewise.
Judge, do you have MacArthur up there?
I don't know. Give me 1 second, Lisa. I'm a little.
Okay.
Can you have them send my granddaughter down here, please?
Yep, she's on her way. I just told him.
Perfect. Thank you. Good morning, Mr. Haysha. How are you?
I'm doing better now that I know that there's a granddaughter in the building.
She's a lot cuter than I am, I'll tell you that.
Well, I don't doubt that for 1 second. We got to get her some screen time.
All right. People against Robert Joseph MacArthur. This is 26G7091562. All right, your appearance.
Your Honor, good morning to you and the staff. Vincent Haysha, with and on behalf of Robert Joseph MacArthur, who's present through Zoom without objection.
All right, Mr. MacArthur, your name, sir?
Good morning, Your Honor. Robert Joseph MacArthur.
Who's this gentleman sitting next to you?
That would be my son, Robert Nicholas MacArthur. How you doing, sir?
Good. What?
Co-defendant case, Judge.
What's that?
It's a co-defendant case. I represent both of the individuals.
I think they sent in, oh, they did. Now I also have Robert Nicholas MacArthur, 26G7091561. Okay. Your appearance again, Robert Nicholas MacArthur.
Vincent Haysha, with and on behalf also with Robert Nicholas MacArthur, who is present through Zoom without objection.
And sir, your name again?
Robert Nicholas MacArthur.
All right, so they're charged with aggravated assault. For purposes of arraignment, do they stand mute and waive formal reading?
Yes, Your Honor.
All right, now I have some concerns. Let's talk about the first one. What do you think that's going to be? Are you sure there's not a conflict?
Your Honor, I've spoken to both Robert Joseph and Robert Nicholas extensively about the aspect of a conflict of interest, about the typical necessity of having separate counsel, about the potential that conflicts could arise throughout the course of a case. I believe that they both understand and acknowledge that that is, I guess, theoretically always a possibility, but in this particular circumstance, do not believe it to be a possibility that will arise. I don't believe that there's a conflict. I think that they have mutual interests. I believe that their defense is extremely similar, and I don't think that that is something that could arise. I just want the record to be clear that it's a conversation I've had separately with father and son, with Robert Joseph and Robert Nicholas, and I do believe that they're knowingly and understandingly moving forward with the same counsel at this point.
Robert Joseph MacArthur, do you understand everything that your lawyer just said?
Yes, sir, I do.
And do you understand everything your lawyer just said, Robert Nicholas MacArthur?
I do as well. Yes, sir.
So you understand whenever there's co-defense and a defense lawyer is representing both, that there certainly is a potential for a conflict of interest to arise. One defendant says, I didn't do it, he did it, or anything else similar there too. That creates a real conflict of interest issue. Do you understand that, Robert Joseph MacArthur?
Yes, sir, I do.
And Robert Nicholas, do you understand? Robert Nicholas MacArthur, do you also understand that?
Yes, sir, I do.
Knowing all that at this point, based on your consultation with your lawyer and based on what he said, do you want him still to represent you at this point, understanding that he's telling the court if a conflict arises, he will take the appropriate steps to make sure that the conflict is resolved. Do you understand that, Mr. MacArthur? Robert Joseph?
Yes, sir.
And you still want him to represent you?
Yes, I do, sir.
And how about you, Robert Nicholas? Do you still want him to represent you?
Yes, sir, I do.
All right. Now, that's one concern. The second concern I have here, I don't mind them appearing by Zoom. What I do worry about is there's a necessity for me to get them printed. I mean, this is not, still a 1-year misdemeanor, and that means they're going to have to come here unless you can figure out some other way. Is there a detective on this from Gibraltar out there by chance?
Not on Zoom.
Okay. They didn't my granddaughter, where'd they take her? Do you know? John, can you go in those?
They walked down with her.
Can you bring her in here? Get her in here, please. All right. So how do you propose that we handle that? They live in Estero Beach. I mean, I don't need them coming back for every proceeding unless there's a trial, but I do need them to get printed.
I understand that completely, Your Honor. I can reach out to Gibraltar and see if there's a way that they can have prints taken out of the state. If it's not a possibility, then they'll have to make arrangements, and I'll communicate with the court and we'll get that done in a reasonable amount of time, Your Honor. It's not something I considered prior to today. Otherwise, I may have had a better answer for you. But I do think if it's something that requires them to travel, then we'll make sure that they travel and make appropriate accommodations.
I'm surprised nobody from Gibraltar's here on this today. Did they know that this was up, or did you just make arrangements to come in
This
today?
has been scheduled for approximately 3 weeks.
We need to cancel the warrants if they haven't been canceled, Lisa, too, on these.
Yeah, they have.
All right. I just don't know anything about it. All right.
The allegation, do you want me to give you a brief summary of the allegation?
Yeah, but give me 1 second.
Sure.
Who was bringing her down, Lisa? I don't know where she is.
John Miklos.
This one. This one.
You know,
This one.
Heather,
No idea.
can you find her and get her in here? Just give me 1 second, will you please? I'm a little pressed right now. Yeah, now you can give me a brief synopsis, if you would, Mr. Asia.
Your Honor, the prosecutor's theory of the case is that that Mr. MacArthur, Mr. Robert Joseph MacArthur, and Mr. Robert Nicholas MacArthur were patrons at a Gibraltar establishment. That at some point during the time that they were at this establishment, that there was an altercation between the complainant and Robert Nicholas MacArthur. That Robert Nicholas MacArthur was injured during that encounter, and that ultimately Robert Joseph and Robert Nicholas, with some sort of malice and an intent to seek out retribution, thereafter attacked this particular complainant. Obviously, we disagree with that, but that is, as alleged, and what I believe to be the prosecutor's theory of the case.
What establishment was this at, Mr. Haysha?
Just one moment, Your Honor. Captain Jim's, Your Honor. I'm not familiar with it, but I believe it to be a local spot.
All right. Okay, here's what I'm going to do. You're asking for a personal bond.
I am.
Any one of these guys have any criminal history?
There's no assaultive history for Robert Joseph MacArthur. In 2011, there was a neglect of duty. It was a matter that involved him failing to, it's a very public matter that involved the circuit court judge in Wayne County and a prosecutor, and a neglect of duty for failing to arrest a sitting judge and a sitting prosecutor.
Wait, say that again?
There was a very public case in 2011 in the Wayne County Circuit Court that involved a criminal defendant that was a circuit court judge. I don't want to put any names out there right now, and a prosecutor. And Mr. MacArthur, while in his capacity in law enforcement, was charged and ultimately pled to neglect of duty for failing to arrest the prosecutor and the judge during the course of that case.
Wow. All right.
That's the sole criminal history. Aside from that, Your Honor, he's been a pillar in the community, coached Little League football, baseball, and basketball in the area of Gibraltar. He was a high school coach for basketball. He owned several businesses and apartment complexes in the Gibraltar area. He's been in law enforcement for longer than I've been alive, with the Sheriff's Department, City of Northville, Inkster, DEA Task Force, Highland Park. He was a City of Detroit transit officer. He doesn't represent a danger to the community or a flight risk.
What does he work for now?
He's currently working security, Your Honor. He has 2 positions that he works for in the state of Florida.
And is he required to carry a firearm?
As a condition of work, Robert, do you carry a firearm as a condition of your employment?
I do, sir. I currently hold a Class G license, and I do work in a school.
School resource officer. I apologize, Your Honor.
And I also work for my church as a security officer for the church that I attend.
Okay. All right, look. So much paperwork to fill out. Here's what I'm doing. I'm going to give you both a personal bond of $5,000. You can leave the state. You can remain in Florida. You cannot violate any law or ordinance. You must appear in court as directed. Neither one of you are to have any contact with James L. King III. No contact with him. You cannot write, phone, see, text, email him, communicate with him, or have any contact with him whatsoever. You're not to have any contact at all. No contact at all with prosecution witnesses except through your lawyer. No contact with prosecution witnesses except through your lawyer. You are not to enter the property address at 29104 North Gibraltar Road in Gibraltar. You're not to go back there. You're not to possess any firearms or dangerous weapons. No firearms, no dangerous weapons. I'm going to allow you to continue to use those except when working, Mr. MacArthur. So I'm going to trust that you have a place to keep that
I do, sir.
firearm on the premises because you're not going to take it out of there. Do we understand that?
Premises, referring to where I work.
Wherever you're working in law in your capacity that requires you to carry a firearm, I'll let you continue to do that. I'm not going to take your job from you effectively by saying you can't use a firearm, but I want you to store it somewhere. I don't want it in your possession except in the course of employment. Do you understand that?
Yes, sir. I understand fully, sir. Thank
And
you.
as for you, that's Robert Joseph. And as for you, Robert Nicholas, you're not to possess any firearms or dangerous weapons whatsoever. I'm going to ask that I'm going to have you return to the Gibraltar Police Department to be fingerprinted and photographed by June the 23rd. I will let you appear by Zoom. If you can work this out differently, Mr. Haysha, I could care less. You know, if you can, I don't think they're going to be able to do what you're suggesting is what I'm trying to tell you nicely. So I'm going to give them 2 weeks to get here. If you get the fingerprinting somehow done where they're here in Gibraltar by two weeks from now, and you should call Detective Robinson on that, I'll be more than happy. I'm not looking to make people travel across the country, but that's what I'm going to have here. Okay. So give me a court date if you would, Lisa, and we'll go from there.
June 23rd at 8:45.
I just want to make sure because I don't see that. Have they been canceled? Have the warrants been canceled?
Yes.
Okay, good. June 23rd at 8:45. Is that good with you, Mr. Haysha?
I'll make it work, Judge.
And I'll let you appear by Zoom too, okay?
Thank you, Your Honor.
All right. Anything else, Mr. Haysha?
Where's that granddaughter?
Right here. Want to say hi? Want to say hi?
I do. Oh, I see her right now, just on the side. Hi, sweetheart. No, that's it for me, Judge. Thank you.
Have a great day. Thanks a lot.
Take care.
Now. Bye. All right.
Judge McNally? Yeah. Quick question. I have Towers Trucking and I have somebody who his job is the manager, Department of Compliance. He says he's under the precedent. Can I, because I know last time you wanted to make sure that they were either somebody who's the president to represent the trucking company.
It's got to be either an officer. What kind of case is this?
It's one of those
Is it a
bridge. I just want
Is it a civil infraction or a criminal case?
It's a civil infraction, Judge.
If civil infraction, I don't mind if an officer appears.
I just want to
But on a misdemeanor, they have to have a lawyer.
Oh, okay.
Okay, misdemeanor, they have to have a lawyer, no matter how big or small.
You have such a cute granddaughter.
Thank you.
Judge, I came in just for her.
Oh, good. So- When?
Now we have a princess in our presence.
I know. Thanks. Thank you. Okay. Stevie Buktalaj. 260-71812.
Judge, if you don't mind, I've got 3 sentences to write on it.
Yeah, you can go work on other things. I'm just kind of.
Okay, Judge, I understand.
Counsel, your appearance.
Good morning, our revenue shy appearing with an update civil litigation.
Your name, sir?
Stevie Buktalaj.
Judge, the victim's on Zoom also.
Okay. And your name, sir? Or ma'am, I don't know who the victim is on this. Let me see.
It's Cassandra Gullah.
Okay, ma'am, your name?
Cassandra Gula.
Good morning.
Good morning.
What are we doing on this? We're gonna go to trial?
Yes, Judge, we're still talking over. We're going to be able to work it out, but in the meantime, we'd like to set this matter if the court is available on the 24th of July. We're showing 4 jury trial. To move the case along.
Who's on this, Ms. Holloway?
Yes, sir.
Is she good with all these dates? She said.
Yes, we worked them out together. The 24th is our preferred date. If the court is not available, then we also proceed.
I can do the 24th. Set for jury trial. That's what you want, right?
Yes, sir.
July 24th at 8:30. And I'm going to set a final pretrial 3 weeks before that, if I can, Lisa.
June 30th at 8:30.
Ms. Alloway, your please.
Good morning, Your Honor. Yeah, 8:52,
All right, that's what I'll do. Final pretrial, June 30, 8:30, July 24th, 8:30 will be the jury trial.
I'll be out of the country on June 30th. Would the court consider a couple of days before or?
Well, they're only in here on Tuesdays. And I don't want to have them sent out. If I have them in here on July this, well, I'm not here July.
You're off that day. We could do June
Of June?
23rd.
Yeah, we can do that. I just don't want them to have to send out notices if this resolves. June the 23rd at 8:30, okay? Do I need to do anything else? You guys weren't here last time, huh?
We were advising.
Okay. All right, anything else? And then I'm going to set jury instruction dates. I'm going to ask you guys to get together and prepare the jury instructions. So I just have to read them. If there's disputes, no problem. I'll resolve the disputes. Okay?
Take care.
Thank you.
Take care.
Thanks, ma'am. I'll see you here in June, okay?
Yep, thank you.
Good luck. Thanks. Song is Feng Zong, 268-6647. Where are you at, Mr. Song?
Yes.
Yeah, 60. You left it in my chambers, you know, didn't it? You just grab her water in the chambers there, please. All right, Mr. Song, your name?
Feng Zong.
They're going to go ahead and dismiss this. They say you got a fishing license down, failure to exhibit a license. They're dismissing it. Case dismissed. You are all set. Wish you well. Good luck.
Okay. Bye. Thank you.
Jordan Chelsea Judge, 26R712668. Good morning.
Good morning. Girl, the neighborhood defender service, B86-432, appearing on behalf of Ms. Judge, who stands to my right. Say your name for the record. Jordan Judge.
So we're proceeding with the exam is the first thing. And that will be exam. It's set for next week. You can't do next week?
Now, Judge, I'm assuming you set it out 2 weeks to the 23rd, I believe.
All right, we're going to do it on June the 23rd at 11:30. And you understand, Jordan Judge, that you have the right to an exam within 7 days of the date of the probable cause conference, but your lawyer would like to have this moved 1 more week. You understand that? And you understand if I grant that request, that means the preliminary exam will not take place within 7 days of the date of the probable cause conference. Do you waive that right? Anybody force you to do that?
No.
All right, I'll accept the waiver. Now, I'm not sure what I'm amending. Request to affect custody text only. What am I doing?
So, Judge, I did speak with Ms. Alloway. My understanding is that the complaining witness is here, spoke with prosecutor's office, and would like to amend the no contact order to effectuate contact text only, because they have children in common. So just to exchange the kids and things of that nature is my understanding. And if Ms. Alloway wants to elaborate on that.
Can you go get Ms. Alloway, please? I'm not sure I understand this. Right now, and I didn't do the arraignment on this, but right now, there's no contact with the victim, Jordan Judge. And then except to effectuate visitation with the minor children through third-party contact only, exchange to occur at the Rockwood Police Station parking lot. So nobody wants that. Your appearance?
Yeah. Good morning, we're all going to be on the people.
Okay, so did you hear what I just read? I didn't do this arraignment. So now what are you guys saying? You don't want there to have to be exchange at the police department?
Your Honor, I spoke to the complainant on this matter, and she said that she would be okay with text messages only regarding custody. Apparently, the kids go to daycare, so if somebody needs to pick them up from daycare, text messages about that would be okay, so long as obviously they're limited solely to just custody.
Okay, so I'll just make a note that as of today, no contact with victim, except to effectuate visitation / custodial exchange. And they may do so by text, correct?
You're right, yeah.
But do they still have to exchange at the police department?
You know, this text is at this point is,
So they can have contact then?
yes, so.
So somebody's gonna bring the child over or children over to the other one, and that's fine.
Yes, sure.
All right, so I'm gonna just delete the whole through third-party contact only. Right?
Yes, the third party that they were using is no longer available, so text messages.
I'm gonna delete that as of June the 19th. They may have contact by text and exchange in person. How's that? So that's what I'll change it to, okay? Does that cover it?
I would like to address bonds briefly, if in addition to those other changes.
What do you want?
So currently, Ms. Judge is on a tether. I understand that this is domestic violence allegation. However, we are asking the tether to be removed. Ms. Judge has no prior criminal history. She was a police officer for 9 years. She worked in Ypsilanti and Wyandotte. And then she actually just recently got a job with Homeland Security back in September. Due to these allegations, she actually lost that employment and now has this tether on. So she's currently unemployed. Going and applying for jobs is very difficult with the tether. Obviously, there's a lot of stigma that comes along with tethers. Not only that, but it's costly. It costs money. She doesn't have employment, so she's not having an income. So it's a lot of negative things that are occurring. Considering that they are allowed to contact now, at least to exchange the children, I don't think that Ms. Judge is a threat to the community. I don't think that she is a threat to Ms. Judge at this point. And additionally, she has no previous history. She is here. We've had constant contact.
This is the victim in the front row, correct? Jordan Alexandria, Judge?
And I did just confirm with the complainant, we don't have any objection to removal of the tether. Of course, with this amended no contact order, contact should just remain in text. And we have no objection, obviously, in the hopes that no issues.
Good. I'm seeing through text, they're still going to exchange the children together, right? Is it one child, multiple children?
To my knowledge, the way that that the exchanges will likely happen is pickups from the daycare. So if, say, the kids are at the daycare, they can pick them up today. So it's likely that they really won't be seeing each other in person.
Okay, I just got done saying no contact with victim except to effectuate visitation, custodial exchange, and may do so by text and exchange in person. You don't want me to have an exchange in person?
One moment, Your Honor. That's no problem, Your Honor.
Okay, then I'll just remove the tether. Tether may be removed. All right, so Lisa, we're going to make sure. But then there's also an order here not to be within 3 miles of the victim. So unless you have a problem, I'm going to go ahead and delete that.
Well, given that the custodial exchanges may happen, we would have no objection to that either.
I'm deleting that they can't be within 3 miles of the victim. So she can be within 3 miles of the victim. Tether no longer required, so we're going to have to give the county jail the notice of that, Lisa. Anything else?
Don't think that's.
Okay. I'm making my notes here, and June 23, we'll see everybody at, what time did I say? 11:30. Can we make it earlier than 11:30, Lisa? Or not really?
Yes, we can do 11, 10:45.
Okay,
Your Honor, the earlier the better. In the hopes that we could just get it done as soon as possible.
how about could we go earlier than that or not really, Lisa?
Yeah, that's fine.
You want to
do 10 or 10:30?
Yeah, let's make it at 10 o'clock, 10 a.m. Okay?
Thank you, Judge.
Thanks a lot. Have a good day. Good luck. Mhm.
Hey, who's in the jail?
Sir, what is your name? Can you unmute or get them to unmute you, please? And tell me what your name is?
My name is Damian Butler.
Butler?
Yes, sir.
Okay.
Okay, I'm just waiting on your attorney, okay?
Yes, ma'am.
It did? You'll like another one of those ones. You got another one? Well, they've wait sprinkle. Wait sprinkle?
You want to pull? If you would. So, thank you. Yeah, thank you.
Good morning.
Do I have anything else down there?
Miss Tucker Davis, can you join the breakout room?
Yes, thank you.
Thank you.
That's too late, but I sent one person in Taurus trucking. Is Lisa on? Should I just tell her to put that back in breakout room with me? Thank you. Lisa, could you put Mr. Flores back in a breakout room with me? He's on Taurus trucking.
I don't, John.
Good.
Judge, put the waste management case
Oh,
there.
thank you. Thank you. All right, waste management, this is, 26SO27217. Good morning, Mr. Powers, your appearance.
Yes, good morning, Your Honor. Sean Powers, P42752 on behalf of Defendant Waste Management.
All right, so this plea is charged to overweight with the understanding that the fines are going to be reduced, fines and costs of $2,100, true?
Yes, correct. Yes, Your Honor.
And you're authorized in that plea on behalf of the defendant?
I am, Your Honor.
To the charge of overweight, responsible or not responsible?
Responsible, Your Honor.
Plea is accepted. Fines and costs are $2,100, and I'll give them till July the 9th to pay on that, okay?
Perfect. Thank you, Your Honor.
Have a great day. Thank you. Do you have a case, Mr. Bukowski?
I do, Judge.
What do you have? Good morning to you, by the way. What do you have?
Good morning. Good. Daniel Gomez. Been a while, Judge.
Did you talk to the prosecutor?
I did. We'd like to set this for exam. I know we've got an exam date scheduled for next week. I'm just getting discovery, and I've got a couple conflicts. I'm hoping that we can just set this for an exam on June 30th if the court is willing.
I doubt it, but let me get the file, okay? Let me get the file. All right. But I don't have it yet. They didn't bring it in. As soon as I get it, I'll call it, okay?
Very good. Thank you, Judge. Am I the last one?
No, I got others, believe me.
And sorry I was late, but I'm up in scenic Flint, Michigan right now. Just left a hearing, so.
You're where?
Flint.
Oh, okay. Well, that's not too far.
Could be worse.
Why they're not bringing those files? Or later. What's that? It's not. Okay. Okay. Listen. Hey, I want to get off the bench here for a couple of minutes, but I'd like to get a couple of these people out of here if any of those files have been filled out. I got Mr. Mikowski out here. I got somebody from Towers Trucking and Mr. Gomez. That I believe is Mr. Mikowski's client.
Yeah, Your Honor, this is Dean Alfonso. I'll bring in Gomez now,
Okay.
or I should say Laura's bringing it in now.
Okay, good enough.
I'll bring that in too.
Thanks.
You're welcome.
Lisa?
Good morning.
Good morning, Your Honor. May I have a breakout room with Mr. Mann, please?
You're Daniel Antonio Gomez, 269-712-442-FY. Ms. Mikowski, your name?
James Mikowski, P62105, appearing on behalf of Daniel Gomez, is appearing via Zoom.
Mr. Gomez, your name?
Daniel Gomez.
All right, I really would prefer not to go all the way to the 30th. Can you do the 23rd?
I can, but I have to be in Brighton by 12 o'clock. I don't know how the court's schedule is with exams that day.
All right, let's just, you're sure this is going to exam?
100%.
All right, Mr. Gomez, you have the right to a preliminary exam within 7 days of the date of the probable cause conference. This is the probable cause conference. Your lawyer is requesting that I adjourn this for 3 weeks until June 30. If I do that, that means that the preliminary exam will not take place within 7 days of today's date. Do you understand that?
Yes, Your Honor.
You wish to waive that right?
Whatever my lawyer advised me, Your Honor.
I understand, but I want to make sure. Do you wish to waive that right?
Yes, Your Honor.
Anybody force you to do that?
No, Your Honor.
All right. Preliminary exam will be June the 30th on this at 10 a.m. Lisa, is that good?
Works for me, Your Honor.
Yes, that's good, Judge.
Okay, June 30th at 10, okay?
Thank you. One other issue. My client is asking for the GPS tether to be removed. He's got some ongoing health issues. He's got bulging discs in his back, and it's interfering with his treatment regimen.
I'm going to have to get the prosecutor in here to get their opinion then, their argument too. Peace. All right, call him in here. We have 249.
Sorry, Judge.
That's all right.
Can we need us Peter for the thanks.
Your appearance.
We're not saying anything on behalf of the people, PA 193.
He wants to address Mr. Mikowski. Go ahead, sir.
My client is asking that the tether be removed. He's got herniated discs, bulging discs, and apparently the tether is interfering with his medical treatment that he's taking. He has no wish to contact the complaining witness. Complaining witness lives several cities over.
Is this the one that happened at Grosse Ile where he was allegedly shooting into a crowd of people?
Oh, well, allegedly, yes.
I'm telling you, I felt like I went on my way to give him such a small bond. I'm not going to delete the requirement of the tether. I don't even need to hear from you. I didn't need to call you in here. So that request, I'm sorry, is going to be denied. Okay. Thank you very much.
Thank you.
Have a good day. Thank you.
Thank you.
One more, Tawas Trucking, 26S118458.
Yes.
All right. What is your position with Tawas Trucking, sir?
I am the DOT compliance manager. I'm actually right underneath the president, and he.
I got to have an officer of the corporation do this, sir. Listen, I'm not changing my mind. I can't do it. He's going to have to zoom in. I'll adjourn it 1 week to June the 16th. We'll make it still at 9:15, but he's going to have to zoom in. I don't care if it's the president or vice president, but I have to have an officer. I've been the ruling up on this and I just can't do it. Okay. So tell the president he's going to have to take 5 minutes. They've already worked it out. If you can get him on the line now, I could do that. He can zoom in.
Yeah, let me, well, you know what? I think he's out of the country right now. I'm sorry.
That's fine. He's going to have to zoom in next week though. Okay.
Okay.
All right. Good enough. Thank you.
Yes, sir. Bye.
Derry Alonzo Emmanuel Mann, 26B712364. Mr. Mann, your name?
Judge, they're in a breakout room with the attorney.
I'm sorry. I thought this was Mr. Mann.
That's Mr. Butler. His attorney is with the prosecutor right now.
I see. Well, I'm going to take a 5-minute recess here. Okay. So we'll be back in a few minutes. Thank you. Everybody stay seated. You can stay seated, Dan. You want to take your.
Can I do this one?
It's just about right there. Yeah.
On 229, representing Mr. Derek Alonzo Emmanuel Mann, who is present on Zoom with his permission.
Sir, you have to start your video.
Yes, sir.
Your name?
Derek Alonzo Emmanuel Mann.
All right. So what you want here is to adjourn the PCC for a week and then go 2 weeks to the exam, correct?
Yes, sir.
That is correct, Your Honor.
So, sir, you have the right to a probable cause conference within 14 days of the date of the arraignment. You have the right to a preliminary exam within 7 days of the date of the probable cause conference. If I adjourn this for a week, that means that the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes, sir.
Do you wish to waive that right?
No, sir.
You want to go to the exam next week?
Can I speak to my attorney in a breakout room again?
As you say, the reason that we're adjourning this is because we just met and we're going to look through the discovery. Is it all right if we have that extra week? Do you agree to adjourn that for 1 more week in order to review the case with you?
If you want to go next week, we'll go next week. It doesn't matter to me. What do you want to do? Sir, talk to me. What are you doing? Talk to me.
I want to do.
Your lawyer wants me to adjourn it. I'm willing to adjourn it. If you don't want to adjourn it, we won't adjourn it. It's up to you.
Yes, I'm willing to adjourn it, sir.
So you waive that right?
Yes.
Anybody force you to do that?
No.
I'll adjourn the PCC to June the 16th. What time are we going to do that? And the preliminary exam to June the 23rd.
June 16th at 8:45 and June 23rd at 10:45.
Okay? 8:45 next week, 10:45 on the 23rd.
Thank
Okay?
you.
So June 16, 8:45, PCC, preliminary exam, June 23rd at 10:45. Anything else, Ms. Tucker Davis?
No, Your Honor, thank you.
Have a good day. Thank you. We'll see you then, sir. Good luck to you.
You can hang up now.
Towers Trucking, did they show back up? Oh, no, we just agreed to adjourn it, right, Lisa? Yeah.
Earned it
Or
1
he was-
week.
Or he was going to call. He was
No,
going to
he
call.
said, he said he was out of town, out of the country, so we adjourned it 1 week.
Okay, good enough. What else do I have here?
I'm getting it ready.
Okay. All right, people against Griffer. Ryan Joseph Griffer, 26B 711-925.
Good morning, Judge and staff, and the young legal assistant next to the judge.
Your name, sir?
John Graziani, attorney on behalf of Mr. Veronica, for who's standing my left. Please identify yourself, sir. Ryan Joseph Griffin. Judge, as you can tell, we're seeking an adjournment of several weeks for additional information. But a very important thing right now in the sheet is the fact that Mr. Griffin be allowed to be back home. It appears that the alleged victim has moved off the premises, and I just want them to make it.
Funny. Is the victim here by chance?
I do not believe that she's here. I spoke very briefly to Ms. Alawi, and she didn't get whether she was here or not.
There was somebody.
Was here, I put her in a breakout room with the prosecutor, and then I haven't seen her since.
All right, so I'm going to redo these bond conditions. Mr. Griffer, you're not to have any contact with the victim in this case. Jennifer Michels, or Michaels, Michels, no contact her. You cannot, no contact with her. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. I'm going to give you a new court date momentarily. You cannot possess firearms. You're not to purchase, possess, or consume alcohol or illegal controlled substances. No firearms, no dangerous weapons, no alcohol, marijuana, or illegal drugs, no contact with her. I'm not going to have any prohibition against you going back to the property address. I'm told that she moved out. And that's it. So you can go back there. And we are all set. We'll give you a new date. Is 2 weeks enough?
2 weeks is fine, Judge.
So we're going to do the 23rd, Lisa. Do you have time?
Yes, 9:15.
9:15. Okay, sir. Do you have any questions?
Yes, sir.
Okay, you can go down the hall, get your notice. Good luck. Thank you. People against Leone. Matthew Blake Leone, 26G 710217.
Good morning, Judge and staff. John Graziani, appearing on behalf of Matthew Leone, and we're asking for an adjournment.
Sir, your name?
Matthew Blake Leone.
Is 2 weeks going to suffice?
2 weeks would be fine, Judge.
Yeah, let's adjourn this one to, but if it's not resolved, I'm going to have to set it for trial. Okay?
Understood, Judge.
We'll set it for June 23rd. What time do we want to do this one, Lisa?
9:30.
At 9:30. Okay, sir?
Sir.
So you can go down the hall and get your notice, and we will see you back here then. Thank you.
Thank you.
People against New York. Denise York, 26S577060A. Your name, ma'am?
Denise York.
You're charged with driving on a suspended. I have a note here that says you paid the speeding ticket. You have the right to an attorney. If you want one, I will give you one. Would you like an attorney?
I just want to deal with pay whatever happens.
So you waive your right to an attorney?
Yeah.
On May 16 of 26, it is alleged that you did operate a motor vehicle with suspended license. They think you were operating that vehicle at Elizabeth Park in the city of Trenton at 2:15 p.m. They think you had a suspended license. That is a misdemeanor, punishable by up to 500 fines, 93 days jail, costs you all those 2 points. You understand that?
Yeah.
And did you sign, read, and understand the advice of rights?
Say that again.
Did you sign, read, and
Oh,
understand?
yeah, I'm fine.
Did you read it and understand it?
Yeah.
If you plead guilty at any time, you'll be giving up all those rights. And we will not be having a trial of any kind. Do you understand that?
Yes.
All right. I'll enter a not guilty plea. If you still wish to waive your right to a lawyer, I'm going to send you to the prosecutor. You can talk to them now.
No, I just want to.
Okay, you're going to go talk to, this is a criminal charge. I just want you to be aware.
Okay.
I'm not saying you're going to jail. I just told you the maximums. So I will enter a not guilty plea. You go negotiate with the prosecutor. If they don't give you what you want, then you can come back and tell me you want a lawyer, okay? I can't hear you.
Have a seat in the hallway, man.
We're going to set you up. The prosecutor will speak with you then. Thanks. Justin Scholes.
Yes, sir.
502-68827-956. Your name?
Justin Scholes.
All right, so you are going to be a winner today. A case dismissed. The officer failed to appear. So I'm going to go ahead and dismiss it. The officer failed to appear. It says witness failed to appear, was told he was on his day off, tried to call his work Uber and received no response. Case dismissed. This was scheduled for 9:45. And he was given more than 15 minutes. It's 10:46. You're all set. Best of luck to you. Thank you.
Thank you, Your Honor.
Victor Matevsky. 680-576. Do I have Mr. Kazmarek out there somewhere? Did you have a lawyer?
No, last time he was here and I decided to fire him and come and present myself, you know.
Oh, yeah, I did allow you to withdraw. Well, I mean, you got to tell us before defendants show up. Call the prosecutor in here, will you, please? They want an adjournment. They want me to adjourn this. You don't want me to adjourn this, do you? Blame.
I wanted to explain myself and represent and you make a decision.
You don't need to explain anything. He's not here. Counsel, your appearance? It's only 10:48, but it seems like 1 o'clock, doesn't it? Listen, I can't adjourn this. I mean, the officer has a conflict, but they got to let him know before this. So I'm gonna, yeah, well, they got to let, I'm not gonna make defendants show up here either, you know, and then, so I'm gonna just indicate officer failed to appear, case dismissed. You're all set. If you were texting while driving, please don't do that.
No, Your Honor, that's what
I believe you. That's fine. You don't have to explain. You're a winner. Go out of here and say you beat the system today.
I actually have a flight to Europe now to prepare with my family. I have $1 same as this beautiful M1 with 87 months.
You're going to Europe?
The flight now, yes.
Today?
Baptism to my baby. Yes. Today.
Nice. Where are you going?
Macedonia.
Very nice. Well, you can go there as a winner today then.
Thank you. What is the next step from now?
You win.
It's my first ticket.
You win. You don't pay nothing. Nothing goes on your record. You're a winner. Okay? Happy baptism and be safe.
Thank you.
Good luck.
Appreciate it.
Damian Deshaun Butler. 216-706-769.
Good morning, Your Honor. Your staff, Attorney Quentin Dox, P number 79657. On behalf of my client, Mr. Butler. Mr. Butler.
And good morning, Your Honor. 893.
Mr. Butler, your name?
Damian Deshaun Butler.
So we still don't have a competency report, right?
That's right, Your Honor. It was evaluated around May 22nd, so it should be coming shortly.
All right, so how long do you want me to adjourn it? Just maybe 3 weeks?
Yeah, I think that's right, Your Honor.
All right, I'll adjourn the competency hearing until June the 30th, Lisa. And we can do 9:30 if you want, Mr. Dox. Good with you?
Yes, Your Honor.
Okay, that's what we'll do. We'll adjourn it until June the 30th at 9:30.
Thank you. Docs has any significant limit? Is that?
You have an exam, Mr. Dox? Mr. Dox?
Yes, Your Honor. I'll be there shortly. I have an exam at 11 and a sentencing at shortly after that, too.
Is that exam going?
I'll speak with my client, Your Honor. I'm not sure.
All right, can you get here quickly, please, okay?
Yes, Your Honor.
Wilkins Alexander III, 26M665-269 A and B.
Good morning, Judge and staff. John Graziani, attorney on behalf of Wilkins Alexander, who's to my left.
What are we doing on this? Your name's
Identify yourself. Roland Alexander III.
I can't go much longer than
Judge,
this.
the situation real quickly, there was a little bit of a shortcoming in the progress test, the parking thing, so we have to set up another one. This is why we're requesting the 3 weeks. Sorry for boring you.
I'm done.
Yes.
I'm gonna go on report on this. Why don't you think about setting a bench trial?
We'll set a bench.
Or jury trial if you need to. I could, huh?
We'll set a jury trial for 3 weeks. And we'll set a bench trial for 3 weeks.
Would you go get the prosecutor to waive a right to a jury trial? Have a seat. I'll set it for a bench trial in 3 weeks and then I'll be happy. Okay, sir? Why don't you
Still want me to get her?
please, well, you're gonna have her fill out a waiver form, bench trial waiver, jury trial waiver form. You can have a seat right behind you, okay? Right at that table there. Could I have Mashoud Hussein? 26B711738. I'm waiting for your lawyer, okay? Lisa, they want an adjournment on this one too, so I could do June the 30th on this. This is not that old. It's a domestic case. But I'm gonna wait for Mr. Graziani to make his way back in.
Now, I was looking for a bench trial or a pre-trial for this case.
Well, I can do another pretrial in 3 weeks, but wait for your lawyer. Just wait for your lawyer. Just wait, okay? He just went in on the other case and Okay, so we're on Hussein now, Mr. Graziani. Your name?
John Graziani, attorney on behalf of Mr. Hussein.
So I can do June the 30th as a final pretrial.
Yes, Judge, that would be fine. And also, there's a separate matter. Shame on me for not giving it to the officer. There's an impeding traffic that you want to take care of.
June 30th at 9 o'clock on this one, okay?
Thank you.
So this will be a final pretrial. Okay? If it doesn't resolve, we'll go to trial on it, okay? Fair enough? Yes?
Yeah.
All right, that's what we'll do.
And there's a separate ticket that we want to trust.
Okay, and I also got Hussein 26F 245909. You got a warrant out for your arrest too.
No, I was just going to take it.
Your name? Your name?
State your name, what should we say?
Your name?
John Graziani, currently on behalf of Mr. Lucen.
You didn't pay this one, 245909, the impeding traffic, did you?
Oh, that's the one, not there, or like, I'll pay,
Judge, with all this stuff going
That one's
on,
defaulted, Judge.
How much does he owe on that, Lisa?
185.
Can you pay that now?
will I be able to go on a payment plan? Probably.
2 weeks, can you do it in 2 weeks? Thank you, John.
I'll make a note, defendant owes 185. Defendant to pay by June 23. Now, if you don't have the money, it's not a problem. You have to call the court and set up an appointment. In other words, just set up a Zoom meeting with me, or you can come in here on it before the due date at 8:30, and I'll be glad to give you an extension, but don't ignore me again, okay? You understand?
Yes.
Okay, so June 23rd, you pay that by, all right? Do you have you're all set. You can go down the hall. If you want a printout, they'll give it to you, okay? Good luck. Counsel, do you have the waiver form?
I do not have the waiver form. She was with someone else, Judge. And I instructed her to come in. She'll be in her few minutes.
All right, I just need her to fill out a waiver.
That's right.
Andrew Webb, Andrew Joseph Ellis Webb. This is 260-82402A.
Was that the Brownstown or Flatiron?
This is Brownstown. Good morning, how are you?
I'm good, and yourself?
Not too bad. Where's Mr. Webb at?
Right here, Your Honor. Just right there.
Your name, Mr. Webb?
Andrew Webb.
I don't understand why you didn't show up for sentencing.
It was work. I missed the court date. I missed it twice.
Go ahead.
For the record, Your Honor, James Schwab, 30720. I spoke to Mr. Webb about this. I would ask the court to recall any warrants that are out for him.
We have done that.
All right. And
what's he doing? Why didn't he bother showing up? This was in April. You can't just come in here and tell me you got work. What are you doing? You end up in jail over a vicious act case.
stupid, just stupid. I also try to tell him the importance of coming to court. I believe he understands that. He has work obligations, but I told him the court has other obligations as well, and much tougher ones. So I'd ask the court to give him another opportunity. He doesn't live that far away. I don't think he has a huge criminal history.
He doesn't, but he failed to appear April 8th. And he came in the 13th and I rescheduled it for him for the 22nd. Then he didn't show up again.
Did the court require a pre-sentence report?
No, it was a dog case. It was a vicious act case. Where do you work at?
Wallbridge.
What are you doing?
I'm stupid, just honestly stupid, forgetting, missing my dates, didn't have it down. I don't even want to make excuse. I messed up and I'm extremely sorry.
You have $200 with you?
I don't have it on me. But I have a card.
You have a debit card?
Yeah.
We can have him use the debit card from there, right, Lisa? We've done that.
Does he have my wallet?
Yes, he can use the debit card at the police station.
10%. You do this again, I'm not going to be even this nice. Do we understand one another? This is silly. You've missed 2 sentencing states now.
Absolutely.
Jeez. All right, we'll give you a sentencing date for June the 25th. June the 25th will be your sentencing, and that will be at 8:45. Now stop doing this. Post your $200 and show up that date. Okay?
Okay.
Come on. That's what we're doing. Good luck.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Robert Eugene Williamson, 260-245-827A and B. Your name, sir? Your name, sir?
Oh, Robert Williamson.
Officer, sergeant, your name or corporal? I can't tell.
Sergeant Mitchell.
James Schwab, 30720.
These guys don't get it, do they? Why didn't you show up? Why didn't he show up?
And my mail goes to, I'm in an apartment complex. And I don't get them, sometimes I don't get them mailed off.
So remember getting stopped, right?
I'm sorry, what? I can't hear, I'm half deaf. I'm sorry, I'm half deaf.
All right, let me put it to you this way. You got stopped. I don't want you to acknowledge that you did, but at some point, it's going to be pretty clear to me that you did get stopped. If you had mail issues, you should have called the courthouse. You should have called the police department. Now you got yourself in a real predicament. What, is there a problem with something I just said? I don't want you to cop an attitude with me. If you do, we're going to have a bigger problem.
No, I'm half deaf. I can barely hear you. I'm half deaf. I can't hear you. That's the problem.
All right. Can you hear me any better now?
Yeah, that's all the problem was. I couldn't hear you before. So what's going on?
Does he stand mute and waive formal reading?
Yes, Your Honor.
I'm entering a not guilty plea. I got it operating with the presence of drugs, and I got a resist, hinder, and obstruct an officer charge. So your lawyer is telling me you stand mute and waive formal reading. Has he been printed on this, Sergeant?
Yes, he has.
I want to know why he hasn't shown up.
I apologize.
Why did you not show up?
I didn't get notice.
Well, you knew you got stopped. You should have called the court. We sent it to 311 Adams. Is that your address?
That's my address, but sometimes things get dropped. Sometimes things get dropped. You know what I mean?
We sent 2 letters there. If they came back, we would have put them in the file.
Oh,
you were supposed to be here on April 30, and then you were supposed to be here on May the 14th, and you didn't show up either time, and I don't have any return envelope or any envelope stamped that was sent back to the courthouse, or it would be in the file. Where does he work?
He's on disability, brother. But he has no prior cases. He did tell me about his mail issues. And
he's got prior cases. I mean, he's got a heck of a history here. Home invasion, 98. Impaired, 99.
You can't hold that against me. You can't hold that against me. You can't hold none of that against me because that was over 12 years ago. You can't hold none of that against me. 10 years or older, they don't hold it against you.
Sure, it is your history. I will tell the court that it is pretty old and you make the right conclusions based on that.
Okay? I'm getting mixed signals. I'm getting mixed signals. Yeah, you're going to talk about my history. It's 10 years or older.
Really? Thank you.
I could just go to some trial with it and then show you that they kept me in the police station for 2 days before they took me to the hospital. Even prove that I had drugs in my system.
Talk about the substance, especially.
They kept me for 15 days in the hospital. And then, now you've been doing this. Just let me go. I'll come to court and I'll take care of it. I promise.
Sir.
I just didn't get notice.
Attorney next time and we'll discuss those issues with you. Today, we're just concentrating on bond.
I was reading your history as I was reading it to myself.
You can't read my history because it's over 10 years old.
Don't interrupt.
Are you dealing with me or him? He's switching me around. Why don't you stop switching me to fuck around, bro?
How about you stop talking and listen?
I'm going to set you wrong now. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. If you're going to be so defiant, that tells me you're a flight risk. 40,000, 10%. No alcohol, no marijuana, no illegal controlled substances. None.
My bond is 40,000?
10%. It could be 40,000.
It can't be because I have 2 misdemeanor charges, bud.
Sit back.
We're going to trial then, bro.
Sit back.
It came in from $750 to 40,000 over nothing. I'm fucking this whole state up then, man.
You got
We're going
about
all the way to
15
Supreme Court. We're going to court on this.
You got about.
You can't
15
sit there and then take me from a $250 bond to 40,000 for nothing.
You just use the F-bomb. You're disrespectful. I think you're a
No,
flight
I'm not.
risk. You got 15.
I'm not. How am I a
convictions
flight
on
risk?
you.
I
Listen,
live right here. This I don't even have a car.
Stop interrupting.
I can't hear
40,000.
for one.
well, you seem to be able to hear when you started to defend yourself. 40,000, 10%. You cannot leave the state, cannot violate the law.
Don't keep me in jail the whole time.
Listen, if you give me one more bit of guff, I'm setting this case for next October, and I'm setting a bond of 100,000 cash. You want to keep going on, tough guy? You want
I'm
to
not
keep
being
going
tough. I
on,
can't-
tough guy? Feel free.
I want a PR bond. I want to go home. I want to go home. I want a PR bond.
40,000. No,
Please.
no, no. You're
Well,
disrespectful.
then I'm suing you then.
Good, sue me. Okay, come on, bring it on. Can't wait.
I'm never going to get out, man.
40,000.
Come on, man, don't do me like
10%.
this.
With the court case, it's possible.
Yeah, I'll do that, but he's not going to yell at me and call.
I didn't mean to yell at you. I can't. I'm deaf. I didn't mean to yell at you.
You use the F.
I apologize. Can we start over?
No,
Please?
no,
Can we start over?
no,
Please?
no, no.
Please, can we start? I can't hear this while I'm yelling. I'm not
You
a tough
use-
guy. I just.
You use the F-bomb with me.
No, I didn't.
Oh, you did?
I never cussed you. I would not disrespect you. I can't. I wouldn't disrespect you like that. I apologize.
Listen,
Please, my mom's dying right now. Will you please let me go home?
I'm convinced you can hear a lot better than you think, or at least letting on, because all of a sudden you were able to comprehend. Now, I'm not going to argue with you. I'm telling you, it's June 11th at 9:30. 40,000, 10%. One more word and I'm setting it for June 25th.
This is a different charge. Why are you doing two different charges? That's not me. What you read right now is that's not me. June 11th. That's not.
We're gonna get you in front
It's
of
two
the
different
court,
people.
and the court could review your bond at that time. And you can discuss the issues with your attorney at that time.
Oh, you're my attorney. Well, so I don't know how it's going on
I
here.
said,
I get 5 different things going on right now. That's all.
June 11th is your next court
Thank you,
date.
sir.
That's what they're saying.
One thing I've decided, Mr. Williamson, I'm not listening to you tough guys. You got it? You want to play tough guy? Get into
I'm not playing
WWF
tough
or
guy.
something. I don't know what to tell you. June 11th.
I'm sorry. I apologize.
No, it's not good enough.
I'm half deaf. I didn't know all the screens were up.
I could set it, I could just find you in contempt of court.
I didn't know that all the
For 30
screens were up.
days. One more word, I'm gonna do that. I'm telling you.
I have mental disabilities. Hold on.
days.
I have mental disabilities.
Cut
Can
them
you give me
off.
1 second?
Cut him off, Lisa, please. Wilkins Alexander III. 267-665, 269, A and B.
Good morning again, Judge. Yeah, John Graziani, anything on behalf of themselves.
Is she in here? Did she come in with a waiver form?
I believe she did, Judge, and I believe she gave it.
Do you have it, Sadie, a waiver of trial by jury form?
It was.
Look, I don't think they're gonna complain if I take a waiver trial and I'm driving on a suspended. Does your client wish to waive his right to a jury trial?
Yes, Judge. It's again, it's just too bad it has to come to this because this matter will be resolved.
Okay.
But I understand where you're coming.
So sir, do you wish to waive your right to a trial by jury?
Yes.
You understand you have a constitutional right to a trial by jury?
Yes.
Do you understand that a trial by jury, 6 people would be impaneled over there, all 6 would have to agree that you're guilty beyond a reasonable doubt in order for you to be convicted. But by waiving your right to a jury trial, I will be the one who will solely decide your guilt or innocence. Do you understand that? You still wish to give up your right to a trial by jury? Anybody force you to do that? No. All right, now let's make sure. Is he going to have a valid license in 3 weeks?
Judge, not to embarrass Mr. Alexander, he will have it. It was just a failure of a stupid parking section. I don't
What
even
is that, the parallel parking or?
parallel park. I don't
It's
even.
not easy. You know what you do? You go to the door, right? Make sure your door is lined up with the driver's door and start turning your wheel right then. You understand? Your passenger door to the driver's door of the parked vehicle. Then start turning your vehicle. It's easy.
get a spark vehicle or a little.
Let's do it on June 30th, Lisa. Is that gonna give him enough time?
Yes, it will, Judge. In fact, he's gonna be scheduling it with next days to get the money down.
Everyone done it? Okay. What time do you want to do this, Lisa? 10 o'clock? I don't think it's gonna end up going.
Yes. Is this a bench trial? I'm sorry.
Yeah.
Okay.
Bench trial.
Yep, 10 o'clock.
June 30th, 10.
Thank you, Judge.
Would you, okay. Any questions?
No questions.
He's not gonna yell at me now, is he?
No, I'm calming it down a little bit.
Huh? Not bad. Boy, I'll tell you. I can't imagine what my dad would have done, huh? 40, 50 years ago. All right, good luck to you. Go down the hall, get your,
Okay.
Lisa, I hate to do this. My sweet little granddaughter would like a donut. Can you have, which one do you want? Huh? A glazed donut. Do you mind having
Yes.
somebody bring a glazed?
I'll bring it down.
Thank you.
Yep.
All right.
Would you
Denise
like
York. Glazed, I guess. 26S5770608. She's paid the B file, by the way. How you doing, ma'am? Your name?
Denise York.
All right, so we're going to adjourn this pretrial. We're going to set it for July. Do I have a judge on July 7th, Lisa?
Just doing PCCs with Judge Hessen.
What's that? Just doing PCCs?
Yeah,
So-
PCCs only.
So we're going to do it at July the 14th, maybe would be my next date.
Yes, July 14th
wants
at 8:30.
She wants 3 weeks. So I'm going to give you till July 14th at 8:30. Okay. Okay.
So what do I need to go to the Secretary of State?
I don't know. It says adjourn for 4 weeks for defendant to get license back. I don't know the status of your license. And then you make sure you try to go, don't procrastinate so we can get it done with on July the 14th.
You say my date come back July 14th at 8:30.
Correct. Okay. Let me just check something here. When's the last time you had a valid license? When's the last time you had a valid license? That's what I thought.
It's been a long time.
We'll go get this taken care of. It doesn't look like it's gonna be that big of an issue, but you gotta go take care of it, okay? Go down the hall, get your notice. Thank you.
Okay, thank you.
All right. I'm ready for Henry Franklin Joseph Lent if you are, Mr.
I am, sir.
Mr. Graziani. This is 26T725297. And I need to have the victim, know if the victim is here on this case, and that's Catherine Berlinski.
No, not on Zoom.
All right. Is anybody by that name in the courtroom right now? Your name, sir?
Henry Rhodes. Sean, on behalf of Henry, and we have no additions, deletions, or corrections, but we do have a statement to make.
Okay.
And we're hoping you adopt the recommendation.
All right. What would you like to say?
Judge, even though this is major hiccup, a very stupid mistake that this gentleman made, he's a very decent individual. Even though he's a well-educated gentleman, like many of us, he's immature for his age, and he had a horrible lapse of judgment. With all due respect to the system, Judge, this young man's already suffered significantly. He's been terminated from his employment since last July. Because of this incident, Judge, he's unemployable, and it appears for the next 5 years, he'll essentially be unemployable from from the employment that he was involved with, Judge.
You went to the University of Michigan?
For undergraduate, yes.
And you were going to be a physician?
He is a physician, Judge. And with all due respect, Judge, he's, like I said, it was a horrible lapse of judgment. Mr. Lent and I have had many discussions, and a lot of young people these days are casual in their conversations and in the dissemination of information. Many times, the new information age is something that is highly destructive, as we witnessed. The AI age is one that can benefit society tremendously, but it's also one that can destroy persons, particularly in this situation. I believe that this gentleman next to me will be able to come back, but it's going to be a heck of a long time before he comes back. He is extremely remorseful. He's had notes that he sent to me, and he's just one of the most decent human beings that I've ever met. Again, this is stupid what was done, but like I said, we're living in a day and age where dissemination.
Why are you doing this to yourself? I mean, I'm looking at a kid here. I remember talking about this. I didn't realize you had this much going for you.
He's a brilliant.
You went to Cranbrook, you went to the University of Michigan, physician residency program. And then you do something silly like this.
Yes. Judge, if I may interject,
were you under the influence of alcohol or drugs at the time you did this?
No, not at all, sir.
I didn't have any evidence of that. Go ahead.
Judge, in this day and age, in this wonderful, and I'm saying it sarcastically, AI age, a lot of folks tend to be very casual about the dissemination of information, and I feel that's essentially what happened over here. There certainly wasn't any malicious intent at that time, and again, this Mr. Len is extremely remorseful. It's cost him his livelihood, and I've advised.
So Corwell found out about this, and they terminated you?
I finished my residency program and I had another job lined up.
Where?
At the same hospital, Corwell Churchill.
Okay.
And then when they ran the background check, they found this charge was pending. So I had to withdrew their offer.
May I add, Judge, since that period of time, he's applied at numerous places, countless places, and has been unsuccessful. We discussed his future and that he's going to have to take a sidestep, and he's going to have to. He'll still be able to practice medicine, but it's going to.
Yeah, but what's he got going on in the row? He also had a B&E without owner's permission.
Judge,
he's got a picture out in a week. For a few days.
With all due respect, the matter is blown out of proportion without getting into tremendous details. This was a situation in which this gentleman tried to help out that individual who was having a mental breakdown, and he had a friendship with that person and knocked on the door responsibly. And again, no malicious intent. And in fact, that alleged victim did not even want to pursue charges. It is a family member of the alleged victim who wishes to pursue charges. Nothing happened there. Nothing was stolen, Judge. It was just simply to try to help out that individual, Judge. That's all that went on for criminal accountants.
One thing I've always said. Do you want to say anything else?
Are you talking to me, Judge?
No, I'm talking to him.
I suppose I should say that I understand clearly now that what I did was wrong. And it wasn't just wrong, it was also directly harmful to somebody that I considered to be a friend and would never have wished to hurt. I don't have a good explanation for how my judgment would have been. So fully without everything that was acceptable. But I apologize to Mr. Lewinsky for what I did and became distressed that I caused her. I wish I could take that back.
Judge, in this, you had numerous people who've done some very, very stupid things in this courtroom. There was one individual years ago who did stupid things, and this individual is in his 60s now. And that individual never received help. Mr. Lent is proceeding extensive help, and he's going to be even more aggressive and
Help where?
get with group therapy, through psychiatric help, through medications, Judge. Mr. Lent realizes that this can't happen again. Otherwise, he'll be permanently
Well, what is he undergoing at Rochester? I wrote down the psychological evaluation and treatment if recommended. Are you seeking, and have you been in mental health treatment?
Yes, I've been staying at a counselor for about the past 2 years.
Yeah.
Rochester area counseling services.
He's also seen a psychiatrist, Judge, and he's taken it very seriously, which he should.
I mean, you must be a bright guy. You know that? You must be a bright guy. I mean, you don't get through Cranbrook and University of Michigan and become a physician unless you're bright and work hard, but you got to use your head. I mean, you just got to use your head.
Yes, I understand that.
It's nothing worse in my view than going to your grave at some point, whether we saying I underachieved. I just can't even imagine that. I'm not going to adopt this recommendation. I think he's remorseful. I think what he did was ridiculous. I told him that. I raised my voice with him at the time of the pre-trial. But I still have a heart. 12 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. Continue your mental health treatment.
Yes.
Is that all at Rochester area counseling?
Yes.
Continue that. I'm not going to pile on with the rest of this, and I have no evidence that alcohol was involved or drugs were involved at this. I know he had a drunk driving 4 years ago, but I'm not going to order that. No contact with Catherine Belinsky at all. You cannot write, phone, see, text, email her, or communicate with her, or have anybody else do any of those things for you or on your behalf. You're going to serve 48 hours of community service. Could have been a lot worse. I do not like this kind of thing. We don't embarrass one another. 48 hours of community service by August the 10th. 48 hours of community service by August the 10th. Fines are 100, costs are 275, victims' rights fee $50, justice assessment $4.25. Probation fees are $240 for 665. Screening fee is $60, $725. Attorney fees of $40, $765. If you violate your probation, could be revoked. You could be incarcerated for 90 days. I don't know why. I'm going out of my way here because I truly believe you're remorseful. But you got to make sure this is the last of your mistakes here.
Yes.
We can't afford to make mistakes. We need to make mistakes, but not mistakes like you're making.
Chuck, I explained to him that a man that appeared in front of you a number of years ago was always doing some very, very stupid things. And now he's in his 60s and he is in the Michigan State prison system. Minimum security, but nonetheless, because of the stupidity and failure to address these issues, he's messed up.
All right, can you pay this now or do you need time? If you need time, I have no problem.
Judge, I would request time.
How much time?
Can you do it 2 months?
Yes.
I'll just make it September 1st. You pay it when you can. I just sense you're remorseful. I'm taking a chance now. Don't let me down.
I appreciate it.
But if you violate, you're going to get 90 days. Do we understand that?
Perfect.
Good. Have a good day. Good luck to you. You'll meet with probation.
Yes.
I don't know which one to take next. Which one do you have a preference?
Judge, I have no preference, sir.
Nicholas William Kalicki, 26, and give me 1 second here, 26W7095671. Your appearance, sir?
John Graziani, appearing on behalf of Nicholas William Goulet, please to my left. Please identify yourself, sir.
Nicholas William Kalicki.
All right. Do I have the victim here, Sarah Hancock? Is she here either on Zoom or in person?
No, not on Zoom.
Is it Haycock or Hancock?
This Hancock, I believe.
Yeah, I think so. All right. She's not here. Have you had a chance to review the report with your client, and are there any material additions, corrections, or deletions?
We've had the opportunity to review no additions, deletions, corrections, Judge. We ask that you adopt the recommendation, and there's been a tremendous amount of suffering. Families here, it's not divided, but they're very sad. The mother and father are in the second row to my left, and
I'd like to talk to Sarah Hancock too. Using language like that. I hate that, Rachel. So she was no choir girl either in this incident.
absolutely, Judge. Absolutely.
But it's not to say that the conduct is justified. Conduct is not justified by words. But still, I mean, that's just terrible language to use. And in fairness, your girlfriends flipped her off and said, F you, mother effer, and then she responds with F you using the N-word. And it just escalated. But why would she get out and say F you, mother effer, your girlfriend? Where's she at? Is she here?
She's not.
They never show up when they do something stupid. I mean, seriously. Right?
Yes.
Yes.
And you got a good lawyer here. But anyway, you want me to adopt this?
Yes, sir.
Would you like to tell me anything, sir?
I can say that I'm sorry that all of a sudden that happened. I'm very remorseful.
This is still your sister.
She is, yes, she is my sister.
I don't understand people that they don't understand these relatives infighting thing. I mean,
Judge, if I may interject again on this, his sister is a former officer in a local jurisdiction who suffered a closed head injury, which exacerbates the relationship. And I've indicated as a result of it that Mr. Kalicki should avoid her, and prior to going to his mother and father's house, he visits them on a regular basis, that he contacted them first to make sure that his sister's not there. It's going to take a long time for her to be rehabilitated if she's ever rehabilitated. Closed head injuries, as you don't judge her. Pretty serious.
Did he spend any time in jail on this? No.
I spent 2 days in custody.
2 days?
Yes.
You did?
Yes. 2 nights, silence.
All right. Anything else anybody wants to say?
Judge, in lieu of court order program, if he could do the community service, he has been working a little bit extra at the Fed to get that's on behalf of the Fed. So at least he has some more flexibility. Corporal term isn't a selection. That is it, sir.
12 months probation. You take it under 76948. I'll need a review hearing date. You cannot leave the state without the consent of the court or violate any law or ordinance. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No contact with the victim, Sarah Hancock. You cannot write, phone, see, text, email her, or have anybody else do any of those things for you on your behalf. You're not to possess firearms. You're not to possess dangerous weapons. You're to obtain and maintain employment and provide proof of that. You're to serve 4 days jail. I'll give you credit for 2. I'll have you serve the other 2 on the court work program. There's a $35 charge for that. You're to attend the domestic violence program with 4-week follow-up. Attend that, complete that. Fines 100, costs 100, 75 victims' rights fee, $50 justice assessment fee. So your fines and costs are 3 1/4. Probation fees are $240 for 565. You have a screening fee of 60. You have attorney fees of 40, court work program fees of 70. Your total here amounts to 735, I believe.
That's correct.
Wait a minute, did I add the attorney fees for $40 or $40?
Yes, attorney fees of 40.
And the court work program fees, good enough, 735. If you violate, your probation could be revoked, you could be incarcerated for 93 days, you have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer. Do you understand that?
I do.
We're gonna give them a review hearing date, Lisa.
June 1st to 27 at 9 o'clock.
June 1st of 27 at 9 a.m. Does he have all this to pay?
Judge, he has most of it to pay. He put about $300 or $400 down.
Yes.
I'm asking for about 2 months, Judge.
$300 down, and I'll have you pay $75 bi-weekly starting beginning June the 22nd, okay?
Thank you, Judge.
So 75 bi-weekly. If somehow something happens, you need more time, call the court. We'll go on Zoom. I'll be glad to give you an extension, okay? Good luck to you. You'll meet with probation and you'll get your review hearing date. You okay? Are you getting? All right, Charles Dewan Boyd. 26W706-997.
Good morning again, Judge and staff. John Grotsky, attorney on behalf of Charles Boyd, who's to my left. Please identify yourself, sir.
Charles Boyd.
All right. I just want to make sure that, first of all, let me just make a record here. His daughter is Tahari Boyd.
Yes.
And I want to make sure that neither she nor Janet Johnson are on Zoom. They're not in the courtroom. There's nobody in the courtroom. Can you confirm that neither one of them are on Zoom, Lisa?
They're not on Zoom.
So have you had a chance to review the pre-sentence report here? And are there any material additions, corrections, or deletions?
Judge, there's no additions, deletions, or corrections. We're asking for basically some guidance at this time, Judge. This is a very complex situation with Mr. Boyd. Mr. Boyd is the custodial parent of the victim in this case. Mr. Boyd's ex-fiancee, who currently is with the daughter, doesn't have custody and doesn't have the capacity to take care of the daughter. This young lady is going to fall through the cracks if we don't address this issue. I'm going to ask that maybe the probation department be involved or possibly the circuit court, but I believe it could be handled by the probation department. What's happened, Judge, is the daughter hasn't been in school since April 6th. She'll have to attend summer school at least. She wants to graduate next year from Brownstown Woodhaven High School. And Mr. Boyd has to at least address the transportation issue. It's just a big mess right now, Judge. And without affecting the terms and conditions of this probation, Judge, we're just asking for you to allow him to at least transport her to the high school and ultimately possibly go back there at the residence, because again, Mr. Boyd is the custodial parent. The other alternative is, with all due respect, it's not a good alternative. So,
sir, I don't understand your conduct here. You slapped your daughter in the face?
Yeah, it was
a stupid action.
Wait a minute. A setup?
No,
Judge, what he meant to say is that he had a meltdown, because we know a lot.
No, but we don't hit our daughters in the face. Yeah.
I'm aware of an incident that occurred. It was stupid. Yeah, it was stupid. It's not. So I've raised my daughter from her retirement myself.
That one moment is not a reflection of my parenting style or household.
I believe you, but you really went off the rails.
I did.
Look, here's what I'm going to do, and I'm glad you're mentioning this. I'm going to adjourn the sentence, and I'm going to tell probation to try to get a hold of the victim and the victim's mother. And tell them the judge would really like to have them in here. At least by Zoom, Lisa. Maybe I can talk to everybody here. So let's adjourn.
Appreciate it.
Let's adjourn the sentence out. Is probation back? I know a couple of them were out yesterday. Are the couple of them out today, Lisa?
I believe Beth is here today.
Well, I'm debating whether or not I should go 2 weeks or 3 weeks.
I think 3 weeks because it appears that Miss O'Donnell is on vacation this week.
Yeah, I'm going to adjourn the sentence to June 30. So Lisa, would you email them and tell them what I'm thinking, that I would like them, Jessica, and you can CC Beth. I'd like her to make phone contact with the victim and her mother and see if I can't get them here, and maybe we can work this out.
Okay, I'll take care of that.
Make phone contact
Thank you.
with victim and her mother. Sir,
Yes, sir.
I can tell you're you're remorseful, but I just,
It was something that
I don't want to make you feel bad, but you cannot hit your daughter in the face.
I'm well aware of that, sir. It was honestly, it was a last judgment, a slip up in that particular.
Yeah, but that was a big slip up. And that permanently affects relationships, whether it's physical injury or not. And here I'm looking at some pictures here too that we'll talk about more in depth on the 30th. Why don't we make it at 9:30 on the 30th, Lisa? And
Okay.
hopefully they will arrange for themselves to be here in person. If not, I understand, but I'd like them here nonetheless, at least by Zoom. Okay? Thank you. Good luck. Go down the hall, get your notice, Philip Russell Conklin, 25R713371. And I also have 26R705091.
Judge, I don't have the attorney here. I've been trying to call him.
Mr. Gonick isn't here?
No.
Did you call his office?
Yeah, we've been round and round about this case. He doesn't reply to emails or phones, but the office talked to Amy on Friday and said that they would Zoom in for a waiver.
Oh, where's the defendant at? Philip Conklin.
He's at the police department. He needed to be printed, so they went and picked him up for today's hearing.
What to do? I mean, it's 11:40.
I can try and call him again.
Would you please?
Your Honor, we're on.
Hi, Lieutenant. Listen, the lawyer isn't here. I'm ready to go, but the lawyer isn't here, so we're going to have to call him. So I don't know if you want to put him back in lockup and wait for us to call you.
Yeah, that's fine.
It's up to you. We'll get a hold. When Mr. Gonick gets in, will you call Rockwood,
Judge, someone's in the waiting room. Let's see.
Okay, let's see.
Kayla Miller.
Oh, that's on her. That's on. Good. People against Philip Russell Conklin, 25R713371. Good morning, Ms. Miller. Your appearance.
Good morning, Your Honor. Kayla Miller, P87446, standing in for the attorney of record, Ben Gonick, and appearing on behalf of Mr. Philip Conklin.
I also have 26R705091. Mr. Conklin, your name.
Philip Russell Conklin.
And Lieutenant, your name.
Detective Lieutenant Steve Mercury, Rockwood Police.
All right, so we have, let's take one thing at a time. I'm going to take the 713371. That's a May 11, 2025 felonious assault. There's a bond of $50,000, 10%, as I understand it. He is going to waive his right to an exam. Is that correct, Ms. Miller?
That's correct, Your Honor.
Sir, you're charged with felonious assault, a 4-year, and you have habitual 4. So that means if you're convicted of it, you could get 15 years. That's a 4-year offense, but it could be a 15-year if it's proven that you have those 3 prior felony convictions, and if you're convicted on this count. Do you understand that?
Yes, sir. Yes, sir.
You have the right to a preliminary exam. By waiving your right to an exam, you're waiving the requirement that the people show that the crime was committed and that you were the one who probably committed the crime, and you'll automatically be bound over for further proceedings to the Criminal Justice Center in Detroit. Do you understand that?
You understand that? Yes, sir.
You gotta stay with me. Are you listening to me and understanding me?
Yes, sir. I hear you.
Do you understand everything I said?
Yes, sir.
You wish to waive your right to an exam?
Yes, sir.
All right. Anybody force you to give up your right to a preliminary exam?
No.
And you still wish to do that?
Yes, sir.
All right, I'll accept the waiver on that case. You're bound over for further proceedings. 50,000, 10% will be the bond. And June the 16th at 9 o'clock will be your court date at the Criminal Justice Center. On 26R705091, Ms. Miller, I know you already stated your appearance, but I just want to make sure he wishes to waive his right to an exam on that charge as well. True?
That's correct, Your Honor.
Is that true, sir? Are you listening to me, sir? Sir, are you?
Yes, sir, I hear you.
What's that?
Yes, sir, I hear you.
So is it true that you wish to waive your right to a preliminary examination on the other case as well?
Yes, sir, it's true.
You're charged with assault with intent to do great bodily harm less than murder by strangulation, which is a 10-year. You also have the 4th offense notice, and you have a domestic violence charge. If you waive your right to an exam on that, if you're convicted of something that carries with it 5 years or more, you could get life. Do you understand that?
I do.
And you still wish to give up your right to a preliminary examination on that charge?
Yes, I do.
Anybody force you to do that?
No, no.
All right, you're bound over for further proceedings to the Frank Murphy Criminal Justice Center on that. June 16th at 9 o'clock. Bond is 50,000, 10%. That's continued, same bond conditions on the charge contained in the complaint and warrant. Do you understand that?
Yes.
All right. Anything else, Ms. Miller?
Your Honor, if I may, would there be able to be a condition added to his bond where if he gets a bed available at Sobriety House, that he would be able to be transferred from the jail to Sobriety House to do inpatient treatment?
Well, I'm going to let the circuit court deal with that in the event of a conviction. I'm not going to change the bond. I'm sorry. I'll keep the bond terms and conditions in effect. If there's a conviction, you can ask the circuit judge, okay?
Understood. Thank you, Your
Nice
Honor.
to have you here, Miller. Thank you very much. Have a great day. Thank you. Good luck, sir. Thanks, Lieutenant.
Thanks, Your Honor.
You guys
Thank you,
ready
Your
to start
Honor.
on your exam?
Wait,
Do you have an exam?
Yes, sir.
Is it going?
That's my listed B.
Okay, I don't have the file, that's all. I promise I got one more case. One more case. Let's take another bite of yours on there. Yeah, take it. You don't bite it. It's okay. Shit. Let me show you.
Surely he's sober and awake today.
He was this morning when I talked to him.
He's probably just still tired.
Yeah.
Take that off, please.
I've gone over the probation letter about safety and
Yeah,
he's fine with that.
let's wait for him to get out here. Morning. You are Aaron Wars. Feeling better this week, Mr. Wars? So, Mr. Wars, this is cause number 25 DCCR 1253. Previously, you were in court, entered a plea of guilty to driving while intoxicated third or more, received that pre-sentence report and reviewed it. Have you both had an opportunity to review that report?
Yes, Judge. Yes, Your Honor.
In addition to that, we received an we received an update, also a memo from probation, I believe it was yesterday or late last week, and you both had an opportunity to review that as well.
Yes, Judge. Yes, Your Honor.
And so, any other issues, Mr. Smith? Obviously, based on the issues last week with Mr. Wars testing positive, there's clearly a need for some intensive treatment. Any reason, though, not to go along with the agreement still?
No, Judge, I think we would amend it because we did not have treatment involved. We would ask for safety placement. Your Honor, I've gone over with Mr. Wars and he agrees that he needs safety.
Okay. So, Mr. Wars, we're going to give you this opportunity today, and I hope you take advantage of it, because if you don't, things could be a whole lot worse. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, in accordance with your agreement, find you guilty of driving while intoxicated third or more, sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that, place you on probation for 10 years. You're ordered to follow all of the rules and conditions of probation. That it will include entering and successfully completing the safety program. And then when you're out, you're going to enter and successfully complete the JCDI program as your aftercare. That will give you a longer period of time with more structure and drug tests and classes and things like that. You're also ordered to serve that 10 days upfront time. It's required by law. You'll be able to serve that while you're waiting to get taken to safety. And then any of the other conditions that probation feels like are necessary. If you follow all of these and do everything that you're supposed to, this is a great opportunity because you'll be able to serve this 10-year sentence while you're out on probation instead of in prison. But the other side of that is if you violate any condition of probation, you can be brought back into court and you would be facing that 10-year sentence that you've already agreed to. Do you understand?
Okay.
I don't see the certification attached to this one. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you need to have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Macon. All right, good luck to you, sir. You can go back with the bailiff.
I'll be able to see you, Jeff.
See, Ms. DeLays, you've got Howard Walker Jr.
Yes, Your Honor.
Morning.
So you say. Wait down the road. Right here in Walker.
Good morning. You're Howard Walker Jr.
Yes, ma'am.
This is 26 DCCR 0082. Mr. Walker's charged with injury to a child, elderly, or disabled individual. It's a first-degree felony. What is the
Your Honor, we'd like to ask for one more reset. I've just gotten all of the discovery. Need to go to the jail and go through it with him. I think, Luke, Mr. Nichols agrees with me on this because he's got his.
I know they had to copy a lot of media.
Okay.
And so it's ready, and I think she either has it or.
I have it,
So.
but I haven't gotten to show him and I've only gotten about halfway through it.
Okay,
Quite a bit.
so we'll do one last reset. And so between now and that next court date, Ms. DeLage will be out to the jail to go over everything, show you everything that she's received. And then we'll get an announcement at that next court date after you see everything, if you still want to go to trial or if there's some agreement that gets worked out. Okay. All right. We'll see you at the next court date.
Thank you.
Thank you. Yes, ma'am. Say, Mr. Wilkerson, you've got Bradford Josie.
Yes.
Bradford Josie.
Good morning. I don't know. Look at you doing your certificate. So there's no agreement. We're just going to go through the motion.
Yes, sir.
Okay.
It's going to play true to 33.
Okay. I'll go through all of them and we'll figure out what we need to do. Good morning, sir. Are you Bradford Josie?
Yes, ma'am.
And Mr. Wilkerson, will your client waive the formal reading of the motion?
Yes, ma'am.
Mr. Josie, the best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And in cause number 25, DCCR 1062, I have a motion to revoke your community supervision. Shows that you were placed on probation October 14th of 2025 for the state jail felony offense of burglary of a building. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest, a Class A misdemeanor, February 22nd of 2026 in Jefferson County. And is that true or not true?
That's true.
Count 2, bless you. Are we changing? Are we?
I'm playing not true to first and second.
Okay.
I'm sorry, I didn't understand.
Count 2 alleges that you committed the offense of burglary of a vehicle, March 9th of 2026 in Jefferson County, Texas. And is that true or not true?
Not true.
Count 3 alleges that you failed to report to the probation office as directed November 18th and December 11th of 2025, and then January 6th of 2026. And is that true or not true?
True.
Count 4 alleges that you failed to report to the probation office for your administrative hearing on February 12th of 2026. And is that true or not true?
It's true.
Count 5 alleges that you failed to immediately report to the probation officer your change of address. And is that true or not true?
That's true.
Count 6 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
That's true.
Count 7 alleges that you were at a location other than your residence at approximately 3:25 a.m. on March 9th of 2026. And is that true or not true?
That's true.
Count 8 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
That's true.
And then count 9 alleges that as of February 12th of 2026, you were $700 behind in your court assessed fees. Is that true or not true?
Yes, ma'am, it's true.
Did you enter your pleas of true to counts 3 through 9 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes.
Now, I don't want to get into, I'm not asking any questions, but with regard to counts 1 and 2, I do want to make everyone aware that if we come here and there's a hearing and you act, I don't want us to have to come and have a hearing, have officers come if in fact there's something that is blatantly true. It's not going to help you if you're not taking responsibility.
Yes.
If you actually didn't do it, that's fine. That's what the hearing is for. But just to not take responsibility doesn't sit well. Does that make sense?
Yes, ma'am.
All right, so are we good with what we played on then?
Yes, ma'am.
Okay, then I'm going to find that you entered your pleas of true to counts 3 through 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I am going to reset your case for a hearing so that the state can bring witnesses with regard to counts 1 and 2. We'll get an updated pre-sentence report done. And I'm guessing
Not long, Judge.
not long, so maybe even on 11 o'clock.
Yes, ma'am.
Okay, so we'll set it on a regular docket date at 11 so we can have any witnesses. Anything that you think is important for me to know, get that information to Mr. Wilkerson. He'll present it to me on your behalf when we come back.
And just for the court's information, Judge, once we have those underlying issues dealt with down the hall, then those pleas will change. So it's I'm just giving you a heads up, because if we set it for a hearing right now today and we're able to get those dealt with beforehand, then we're subpoenaing witnesses when a hearing wouldn't be.
Well, that's why I'm saying I don't want to do that. So if they're true, they're true. I don't want to, I mean, if you need time to take care of something, that's one thing, but to stand and swear under oath that something's true or not true is putting Mr. Josie in a position of, I don't know what you mean by taking care of them, but if he's going to go plea on some cases down the hall and he just said under oath that it's not true, then we have an issue.
I would like to establish on my square.
Hold on. I want you to talk to Mr. Wilkerson. Let's figure out the timing of all this, because I don't want to do it this way, if that makes sense. So I don't want him to have to subpoena witnesses. I don't want to get close and then we keep doing this and we show up and then there's some deal that's made and we've got officers who either just got off a night or whatever that had no reason to have to be here. So I've taken the pleas. I'm going to reset it at this point for a sentencing hearing. However, I want to know within at least a week before that hearing, if I want Mr. Coleman to know if he has to get those witnesses here.
Yeah.
At least 7 days. Okay. All right. You can go back with the bailiff.
Thank you.
Thanks, Judge.
Thank you, Your Honor.
Yes, sir. We're going to set for that and then we're going to hopefully hear what we need to, or I'm going to be very excited. Sir Samuel, are you ready on Eric Hebert?
Yes. I'm ready to ask for. Yes.
Yes. That's actually Eric Hebert. Yes.
I don't know what's happening.
Yes. Eric.
What Hebert says. Eric Hebert. Okay, thanks. Sorry.
Good morning.
Good morning. Morning.
Here we go. Good one. Very well.
Good morning. Are you Eric Hebert?
Yes, ma'am.
And this, we've got two cases, 21-37340 and 21-37341. Both of those cases, Mr. Hebert is on probation and motions to revoke those probations have been filed. And what is the announcement?
Judge, if I may,
He has a new DWI third. I've spoken with this officer, Ms. Kane, about that. I checked last week. It had not been received. Mr. Nichols was kind enough to check again this morning. The blood test results are in progress, or whatever that means. So I would ask the court if we could either go through the motion, see what pleas he will enter or hold for maybe 30 days just to allow that new case to come in. We had discussed safety as a possible resolution to pose to the court. Obviously, you can go with the new case outstanding. Obviously, the new case I will not dismiss. And obviously, the court would want to see the new offense before you would determine if safety would even be an equitable option. So that's kind of where we are. Whatever you want to do, either go through it or reset it, and we'll stay on top of that new offense for March.
I would like, that's the agreement with the defense, yeah.
I mean, I don't guess it mattered. At some point, he'll have to enter pleas of true or not true. If y'all want to go ahead and do that, and then we can reset it.
I mean, that would help me expedite that case, but I don't want to put him in a position where he pleads true to it and doesn't get safety and thinks
Well, that's going to be, and I mean, if you're on probation for driving while intoxicated, third, and there's another one, I don't want there to be any thought that I will for sure go along with something like that. It's going to take me looking at, I have no idea right now, but that just off the top of my head sounds like a big no, but I'll, obviously see the new case and look at what's been going on in this probation. I just, I don't want I don't think an agreement right now to that.
Your Honor, I understand that. I've spoken with the prosecutor. I've explained to Mr. Hebert the position that we're in, and that's not a part of the understanding that there's any
agreement. No agreement. So it's just what you guys obviously would recommend. Sure. So do we want to go through the motion today then?
We can.
Or
I'd rather have the, which one would expedite the,
a plea would, because I could push it through without the lap. But if in all candor, if everybody wants all the information, just let me make a call and ask them to move it along.
All right. We'll just reset. I'll just do a normal reset.
Thank you.
See if y'all can get that taken care of.
Yes, ma'am.
All right, and go back to the bailiff. Jarrell Lee, oh, she's not over there. Jarrell Lee is being dismissed, so he can be taken back. Just I'm signing that now.
Hey.
Let's take care of Mr. Parker. Can we take care of Isis Martin?
Okay.
Isis Martin.
I know that you need my file inspection.
Good morning. Are you Isis Martin?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Your Honor.
Ms. Martin, in clause number 25, DCCR 1827, you're charged with the second-degree felony offense of robbery, and that's from October 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you?
Yes, ma'am.
You have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Ms. Martin's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. Mr. Smith, what is the state's position with regard to a bond reduction based on the nature of the plea?
Yes,
I'm sorry?
She has no criminal history. This is only arrest.
All right, so you don't have any objection to it? So, Ms. Martin, what I'm going to do between now and sentencing is reduce your bond to $1,000, and I'm going to make that a personal bond. So that means you don't have to pay any money. You're just going to get out of jail. But there's some very important things about that, okay? The first is that if you don't show up for court, then they can come after you for that $1,000. But that's probably going to be the least of your worries if you don't show up for court. If you don't show up for court, you run the risk of me not accepting the plea agreement, and things could obviously be much worse. The first thing you do when you're released from custody is go to the probation department. You're going to get some paperwork today from probation. It tells you where to go so that they can start that process to get that pre-sentence report done. If you don't go to straight there, you also run the risk of me not accepting the plea agreement. Do you understand that as well? Yes, ma'am. And then also a condition of your bond is that you have absolutely no contact or communication with Harmony Bodner. That obviously means in person, but it means any other way as well. So you can't send messages through other people. You can't send messages on your phone, by text or Snapchat or whatever else exists out there. Do you understand? Yes. Do y'all live anywhere close to each other? No. Okay, so there's no reason for you to have any contact with her. So you need to show me between now and when you come back that you can do everything you're supposed to, so I don't have any issues with putting you on that probation, okay? Yes. All right, we'll see you back at sentencing. Hector Wiggins, Mr. Parker. Hector Wiggins.
Substance abuse, quarantine is fine. But I do with this.
And everybody knows that we reset Radford today's fine. They love us. So that we could do it after that co-defendant.
Oh, okay. I'm sorry. I was just going on your email that you wanted to bring.
No, but this morning he came and talked to me.
Oh, okay. That makes sense. That's all I need.
He had talked to you. Jacorian Flemings is getting reset.
It's needed to talk to them, so that's good.
Okay. All right, sir. Are you Hector Wiggins Jr.?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Your Honor.
Mr. Wiggins, in cause number 24, DCCR 0548, you're charged with a state jail felony offense of theft of property with previous convictions. And that's from November 4th of 2023. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes,
and because you did what they charged you with?
Yes, ma'am.
Your indictment also alleges you were previously convicted of theft, July 14th of 2022 in Montgomery County, Texas. 2 cases on that day, September 9th of 2022 in Montgomery County, February 27th of 2023 in Harris County, and 2 cases on that date in Harris County. And are all those prior convictions true?
Yes, ma'am.
Did you enter your plea of true also to those freely and voluntarily?
Yes, ma'am.
And because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
So what is the, kind of what are those latest? The 22 and 23 cases, some punishments on those?
Got to figure out, got something for you, Judge. I just need to-
He's on vigils and
That's what I figured just based on the counties. Thank you. Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Wiggins is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find those prior counts true. Find sufficient evidence to find you guilty. And at this time, find you guilty of the state jail felony offense of theft of property with previous convictions. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And so, Mr. Wiggins, you've done a whole lot in the last few years with regard to thefts. And I want to make sure you understand that if you're back in Jefferson County and you commit a theft again, it's not going to go this well. You now have enough prior cases to where you probably could be enhanced potentially to a 3rd-degree felony and go to TDC for up to 10 years. So you're okay this time. You got your deal. I went along with it. But if you continue to do that, it's just going to get worse and worse every single time. Do you understand?
Yes, ma'am.
All right, and go back with the bailiff.
And Your Honor, we've emailed the attachment.
Okay.
Discovery.
Thank you.
I have 2 of them in advance.
Thank you. Brent Smith.
Hold on,
Yeah.
Judge. I haven't gotten this time to, I've got it. In the version that was with ISF.
Let's take care of Jesus Garcia, Mr. Parker, since it's ready, and then I'll give you a minute to work on the rest of them.
You call me?
Jesus Garcia, so let's go ahead and do that one, and then I'll give you a break
This
to
is
take.
another one that I don't have. We've already emailed the discovery
Thank
attachment.
you.
We've always had it in my file and they're not there.
And is he pleading on just one of these?
Yeah, pleading on the firearm, and just
Okay.
missing the other.
Thank you.
This one, Judge, and just so you know, the court, we brought him down here from Minnesota. He's also serving time up there. He wanted to come back and resolve these.
Okay. Perfect.
That's the reason to try to wrap them all up today.
Thank you. All right, sir, are you Jesus Marin Garcia? And Mr. Parker, will your client waive the formal reading of the indictment?
He will, Judge.
Mr. Garcia, in cause number 24 DCCR 0586, you're charged with a 3rd-degree felony offense of unlawful possession of a firearm by a felon, and that's from July 14th of 2023. How do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Speak up, please.
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Marin Garcia is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon, sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign a dismissal when it comes through in clause number 24 DCCR 0587 as part of this agreement. It will also run concurrently with any case that you're currently serving in Minnesota as well. All right. I'm handing you the trial court certification. That shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required by law to read it. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can ask Mr. Parker. All right. Good luck to you, sir. Thank you.
Judge, I think they filed a motion to dismiss it on Lee. I don't know if you got it.
I already signed it and I already told them that they could let him go back. Thank you. And I'll sign, don't forget to send Garcia's, thank you.
It's already been emailed.
I meant to just,
Oh,
yeah,
okay.
but that too, thank you. See, Mr. Rojas, you've got Byron Morris. Byron Morris. Are you doing paperwork? Okay, I don't have it yet. I'll hold it.
He hasn't been printed yet. I don't.
Let's see, who do you have this ready?
Hold off on him.
How about, let's do Destiny Vargas, please. Morning.
Good morning.
Hey.
Are we going to count one?
Yeah.
Good morning, ma'am. Are you Destiny Vargas? And Mr. Rojas, will your client waive the formal reading of the indictment?
You can go, Your Honor.
Ms. Vargas, in cause number 26 DCCR 0081, the state has elected to proceed on count one only. It alleges that you committed the third-degree felony offense of harassment of a public servant from July 11th of 2025. And how do you plead to that charge? Guilty. Are you pleading guilty freely and voluntarily? Yes, sir. And are you pleading guilty because you actually did what they charged you with? Yes, sir. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Yes, I did. Do you fully understand them? I do. And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Yes. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Yes. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Vargas is not competent?
No, Your Honor.
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, ma'am. You go back to the bailiff. Quentin Sells, it's a competency, right?
Yes.
Quentin Sells.
Quentin Sells. Now.
Let's see. Maybe, I'm not sure.
Good morning. Are you Quentin Sells?
Yes.
And we've got cause numbers 25 DCCR 1473, 1474, and 1475. Mr. Sells is charged in each of those cases with assault on peace officer. I'm going to take judicial notice of the court's file in all three of those cases. Mr. Sells was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I have received the report from them. In that, it includes a trial competency evaluation report dated May 4th of 2026. The opinion in that evaluation from a Dr. Emery is that Mr. Sells is currently not competent to stand trial and that further treatment would be necessary for competency restoration. In addition to that, I also have the forensic psychiatry report, which is dated May 5th of 2026. Also, it is from a Dr. Shahani, also has that same opinion that Mr. Sells is still not competent to stand trial. Then I also have a physician certificate of medical examination for mental illness. This is from Dr. Shahani, dated May 5th of 2026. It makes the finding as well that Mr. Sells is not competent. It does state that he does not meet the criteria for inpatient, but would meet the criteria for an outpatient commitment for competency restoration, that the nature of his mental illness is severe and persistent, and that without treatment, he would continue to decompose and or deteriorate and not achieve competency. I also have a physician certificate of medical examination from a Dr. Polizzato. This is dated, well, let's see, May 13th of 2026. It has the same finding that Mr. Sells is still not competent to stand trial, but that outpatient commitment is what he meets the criteria for, and that he would require further treatment for competency restoration. Is there any other evidence with regard to competency? Mr. Rojas?
No, Your Honor.
Mr. Coleman?
No, Judge.
So obviously, you both know, we all know that we do not have an outpatient competency restoration program here in Jefferson County. And so I will have no choice but to order further inpatient treatment at the appropriate facility. Hold on just a second. And so I am going to find at this time that Mr. Sells is still not competent to stand trial, that he is mentally ill, and that because of that, it is severe and persistent, and that if not treated, he would experience deterioration and the inability to function independently, and that treatment would be necessary. I'm going to order treatment at this point in an inpatient facility for a period of not to exceed 1 year under the civil commitment, and that we will await report at that time. If something occurs before then where competency is restored, then they will let us know immediately.
Judge, I would like to say, I'm sorry to interrupt the court, but given the nature of these charges, the next time we are in court, if we are in a similar situation, the state will reconsider a way forward
Okay.
in these cases.
Okay, perfect. I know there's some civil locally, as a civil commitment that can be taken care of, but let's see if we can get maybe competency restoration between now and the next court date. If not, then we'll go forward that time. So you're going to go back to a hospital, follow all of their rules, okay? So that you can get better, take your medicine, and then we'll see if we can get your case taken care of.
I went to the health center and I went to all the conferences.
Right.
We've been to the conference with our spouse.
Right. I think the doctors still think they think you need a little more treatment so that you understand all of your legal proceedings. Okay. All right. You can go back with the bailiff. Mr. Rojas will visit with you. Thank you. Smith, I don't think there's any expectation of restoration. I think there's more of an issue of. So anyway, take a look at it.
Yes, Judge. I think there's another way we can go.
Okay.
With this.
I agree.
Next time.
Johnny Segita or Segata?
I think it's a good.
Johnny Segita. Johnny what? Good morning. Are you Johnny Segata Jr.?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
Here you go, y'all.
Mr. Segita, in cause number 26, DCCR 0795, you're charged with the second-degree felony offense of burglary of a habitation from April 21st of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 10 years in prison, which means you're leaving your punishment up to me. And as long as I don't give you more than 10 years, I can give you 10, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing. But as long as I stay within that range, you are giving up your right to appeal. Do you understand? I want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. The first is if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them.
Yes, ma'am.
If we go forward this way, you're waiving that. Is that what you want to do?
Yes, ma'am.
Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, it looks like as part of that agreement, the state is agreeing to dismiss cause number 26 DCCR 0796. Is that your understanding? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Segata is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing. And the probation department will do a pre-sentence report that'll give me more information about your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Rojas. He'll present it to me on your behalf when we come back. Okay, you can go back with the bailiff. What about Byron Morris? I have it. Let's do Byron.
Byron Morris. Morris. Byron.
Well, maybe some stuff. Hey. It's all right. Good morning, sir. Are you Byron Jamal Morris?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Morris, in cause number 15-21651, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 21st of 2016 for the second-degree felony offense of burglary of a habitation, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count one alleges that you committed the new offense of public intoxication November 6th of 2025. And is that true or not true?
That's true.
Count two alleges that you failed to report to the Jefferson County Probation Department for your administrative hearing December 18th of 2025. Is that true or not true?
Yes, ma'am. True. True.
Count three alleges that you failed to comply with the curfew and that you were outside of your approved residence at approximately 11:59 p.m. November 6th of 2025. And is that true or not true?
True.
Count four alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you admitted to using alcohol on September 15th of 2025. Is that true or not true?
Not true.
Count five alleges that you're behind in your court assessed fees as of January 14th, 2026 in the amount of $7,711. And is that true or not true?
True, Your Honor.
Did you enter your pleas of true to counts 2, 3, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 5 years in prison. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Morris is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'm going to reset your case for sentencing so that the probation department can do an updated report. Also, so that the state can bring any witnesses with regard to counts 1 and 4. And I'm assuming if there's an officer, even with the public intoxication, it wouldn't be longer than a regular day. We can add it to the end. All right, so we'll set this so that we have time for a couple of witnesses just on a regular Tuesday docket. Anything that you think is important for me to know, make sure you get that to Mr. Rojas and he'll present it to me on your behalf when you come back.
Yes, ma'am.
Okay, you go back with the bailiff.
Thank you, Your Honor. Thank you.
Thank you. I show that it was reset. Mm-hmm.
I was not asked if you shouldn't file, and I'm gonna. I'm sorry.
That's okay. Okay. Let's. So good. Mr. Lewis, you've got Avriona Dorsey.
Dorsey.
I think I need to sign that, Your Honor.
Okay, I'll call it as soon as she's ready. Do you need, oh, she's already doing another one.